Before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Good morning. Mr. Shipman, you ready?
May it please the court. Good morning. My name is Gary Shipman. I am counsel for the appellant. I'd like to reserve 5 minutes for rebuttal. U.S. Tobacco is a North Carolina agricultural cooperative which the North Carolina Cooperative Marketing Act mandates be organized as a nonprofit corporation. Much has changed since its formation in 1946 and the end of the federal price support program in 2004. In this de novo review of the trial court's dismissal of the plaintiff's complaint, the first issue for determination by this court is to ascertain the intent of the North Carolina legislature in determining what it meant when it stated, quote, so far as appropriate, the provisions of the North Carolina Business Corporation Act would be applied to every cooperative association with capital stock, except where the provisions of the North Carolina Business Corporation Act, quote, are in conflict with or inconsistent with.
If the Business Corporation Act does apply as opposed to the Nonprofits Act, can you still prevail?
We did not plead a claim.
Right. So are you waiving that, any argument then, if the Business Corporation Act applies? Are you waiving any argument
given
that you can prevail nonetheless?
Your Honor, we have pled, you'll see some of the overlapping provisions of dissolution under the North Carolina Business Corporation Act. For instance, assets are being wasted and misapplied. And that's because of the fundamental nature of cooperatives.
Counsel, to follow up on that point, while there are some overlapping provisions, you mentioned one, I think the prejudice to a shareholder or injury to a shareholder is another. I don't think, maybe I'm wrong, even if you pled that, you argued that on appeal. Am I correct in that?
Your Honor, I think you're correct, because we are arguing that because of the unique nature of cooperatives, which are mandated to be organized as a nonprofit corporation, that consistent with how the Wisconsin Supreme Court tackled this issue, then certainly they must be dissolved pursuant to the provisions of a Nonprofit Corporation Act, because they are not the same. Stockholders in a business corporation are not the same as members in a nonprofit agricultural cooperation.
But if you read, if the argument is that because you're a nonprofit, that necessarily requires you to be dissolved under the nonprofit provisions, doesn't that read away the provisions that talk about the existence of organization by capital stock or not capital stock? I mean, what would, if the very fact that you're nonprofit means you go there, what's the point of the capital stock language?
First, to be clear, we are not contending that merely because they're a nonprofit, you apply the North Carolina Nonprofit Corporation Act. We are contending because they are a nonprofit agricultural marketing cooperative.
But I think, to follow up on Judge Quattlebaum's question, they do issue capital stock, which just a plain reading of the act would indicate to me that the Business Corporation Act applies. So I'm not sure you had an answer for Judge Quattlebaum's question about what about that language,
Judge,
about capital stock.
Thank you. As we've pointed out in our brief, cooperatives organized with capital stock grant no greater rights to its members than cooperatives organized without capital stock. All that a cooperative with capital stock enables a cooperative to do is accumulate capital. That's it. No greater rights are granted to the members of a nonprofit agricultural cooperative with capital stock than without. And look at the differences between the rights of a shareholder and the rights of a member. For instance, members of a nonprofit agricultural cooperative have no rights to the accumulated capital. Next, their membership can be redeemed for $5. Next, whatever is distributed in a cooperative is not distributed in accordance with total membership. It's distributed in accordance with principles of cooperation only to those who patronize the cooperative.
Counsel, I think those are fair and reasonable points. I don't quarrel with them at all, but it seems like those points go to the question of whether it was reasonable to have this bright line delineating point of capital stock or not with respect to a cooperative. And it may be that as a matter of policy kind of doesn't make sense. And you've pointed out some reasons where that might be the case, but it seems like your arguments are really asking us to disregard that language. Maybe I'm misunderstanding you. And if so, please clarify.
Sure, Judge Gregory, thank you for the question. If the legislature had intended that the provisions of the North Carolina Business Corporation Act apply to all aspects of a nonprofit corporation with capital stock, it clearly would have said so. Instead, it said you apply it as appropriate. That has to be a fact-specific inquiry. For instance, what would be an appropriate application of the North Carolina Business Corporation Act to the acts of a nonprofit agricultural cooperative? For instance, the duties of a member to other members. North Carolina Business Corporation shareholders owe no duties to other shareholders. They owe no duties, with some exceptions, to the corporation. What about the duties of members of a board of directors? Business judgment rule. Those kinds of principles clearly should apply as appropriate to those kinds of things. But when we're talking about a dissolution and the purposes for which this cooperative was formed no longer exist, when they can no longer act cooperatively because of market forces beyond their control, then it is more appropriate, it is more fitting to apply the unique provisions of the North Carolina Nonprofit Corporation Act, because the purposes for which this cooperative was formed no longer exist, or at least that is a question of fact to be determined by a fact finder, not at the 12B6 level. So again, we think we have pointed out the unique differences between a cooperative and a business corporation, Judge Gregory, some of which I have highlighted. We have pointed out the differences between the rights of members in a cooperative versus the rights of a shareholder in a business corporation. And with respect then to the declaratory judgment action that was dismissed by the trial court, we contend that given that that was premised upon an application of the North Carolina Business Corporation Act, and given that the declaratory judgment action is so intertwined with the allegations of the judicial dissolution claim, that the trial court erred in dismissing that claim and abused its discretion in so doing. I'll be happy to answer any other questions that you might have at this point, but otherwise I'd reserve my remaining time for rebuttal.
Mr. Chairman, before you sit down.
Yes, sir.
And I'm not going to go over it because Judge Quattlebaum and Judge Beck have asked the question, but I had the same concern. It seems like you were saying because that language of capital stock made no difference to you meaning your client, then it shouldn't make it a difference in whether or not which provision will be applicable for dissolution. But then you came back and you said, well, wait, there's an exception. But can you just help me a little bit more? It didn't say unless appropriate, except where the provisions of the act are in conflict with or inconsistent with the express provisions of this subchapter. Can you just tell me, make it clear, what is expressly in conflict? It didn't say if something about your company is different and the things you seem to be delineating. It talks about a statutory determination of conflict and inconsistency. What is the statutory inconsistency that would apply to the exception?
First, the as appropriate language comes before, and then next, it would not be appropriate and it would be inconsistent with the North Carolina Cooperative Marketing Act to apply principles of investment-backed expectations, and where a corporation is not being conducted to the advantage of shareholders. Cooperatives are not to be conducted to the advantage of shareholders. Profit is the antithesis of a co-op. Co-ops exist for the profits, to make profits for the members who patronize them, not for all of the members of a cooperative. So applying principles of a business corporation where shareholders' legitimate investment-backed expectations as a stockholder may be frustrated. It's just apples and oranges, we contend, to the concept of an agricultural cooperative that is organized as a nonprofit with capital stock.
To follow up, Chief, can I ask one follow-up to that response? Yeah, to follow up on Chief Judge Gregory's question, your response, I understand your argument, but can you point or identify a specific statutory citation by section number that you say is in express conflict with the capital stock provision?
When you look at the dissolution provisions of the North Carolina Business Corporation Act, GS 55-14-30, when dissolution is ordered, when the business is not being, quote, conducted to the advantage of stockholders, for the protection of the rights or interest of stockholders. Members of a cooperative have none. When the shareholders are deadlocked, there are limited things upon the shareholders don't vote on the business of this cooperative. The board does. All the stockholders here do is elect the regional directors. They function, they operate totally different. Rights of appraisal. Shareholders of a business corporation have rights of appraisal. Members of a nonprofit corporation have no right of appraisal. This cooperative have even used the provisions of the North Carolina Nonprofit Corporation Act, the Rigby case, to deny members of this cooperative rights which they otherwise would have had under the North Carolina Business Corporation Act. So this cooperative itself has relied upon the provisions of the North Carolina Nonprofit Corporation Act, not the Business Corporation Act, for its own internal affairs relating to members. So again, I think we've addressed many of these issues, but again, thank you. I'll reserve the rest of my time. Thank you.
Thank you, Mr. Shipman.
Yes.
Mr. Whitman.
Thank you, Chief Judge Gregory. May it please the court. Good morning. My name is Lee Whitman. I'm from the Raleigh, North Carolina law firm Wyrick Robbins, Yates & Pun. I'm general outside counsel for the United States Tobacco Cooperative. I'm also its litigation counsel in the Speaks case. Your Honors, for the reasons set forth in our appellee's brief and in the evidentiary record, we contend that Judge Devers' order dismissing the amended complaint with prejudice should be affirmed by this court, mainly because the plaintiffs pled the wrong standard for dissolution. But Judge Devers didn't stop there. Even if they had pled the right standard, Judge Devers' order analyzes the complaint, the allegations of complaint taken in the light most favorable to the plaintiffs under the 55A 14-30 dissolution provisions, and likewise found that even on their own allegations in this long complaint, they could not state a plausible claim. Finally, Judge Devers correctly and properly dismissed the declaratory judgment action as well, finding that it was duplicative of the dissolution claim, that it served no reasonable, useful purpose, and making the point that the Declaratory Judgment Act itself does not form an independent basis for relief. Your Honors, the 12B6 standard in federal court is much more stringent than the standard that Mr. Shipman and I have in state courts in North Carolina. The complaint in federal court must state a plausible claim for relief, that the court, that permits the court, the district court, to infer more than the possibility of misconduct. The reason that I raised that, Your Honors, is it's very important. There are no allegations of misconduct in this amended complaint as against my client. There are no allegations that
into the Business Corporation Act versus the Cooperative Act
Yes.
issue. Mr. Shipman says that language as appropriate makes all the difference to his client.
Right.
That we shouldn't be focusing just on the issuance of capital stock or not. What's your response to his argument about the as appropriate language?
Yes, Your Honor. Thank you, Judge Thacker, for the question. I believe Mr. Shipman, who is a strong advocate for his clients and has been for many years, is making the only argument that he can. But that argument goes to the legislation. This decision has already been made by the North Carolina General Assembly. They drew a bright line in the sand that assists anybody reviewing Chapter 54, the Marketing Act, in determining which dissolution provisions apply. It's rare that there is a bright line drawn this clearly for litigants. It is right there in Chapter 54. And it's not just, I think Mr. Shipman's arguments would have more viability, Judge Thacker, if 54-142 existed in a vacuum, but it doesn't. The legislature also passed 54-142.1. So it did both. And the only distinction, the only language that is different in 142 and 142.1, other than reference to the Business Corporation Act or the Nonprofit Act, is the word with or without capital stock.
Well, how do those statutory, those statutes that you referenced cancel out the four words, so far as appropriate?
Right. That's the right question under statutory interpretation, Chief Judge Gregory. And I will state this: there are no cases that provide us with any direction on that. And so what we have to do from a statutory interpretation perspective when we're analyzing this is essentially the way to read this, because that language appears in 142 and 142.1. Right. It's identical. The only real difference between what the legislature has done is said, if you have capital stock, you have shareholders. And if you have shareholders, they have rights. And the Business Corporation Act goes to shareholders' rights. It makes complete sense, logical and analytical sense for a capital stock corporation to have the dissolution provisions in the Business Corporation Act. Now,
the only problem is that as a court, we have to construe statutory language for what it is.
Right.
Just like you mentioned, other provisions, they had opportunities to clear this up, and by striking those four words, it made it a lot easier. But we can't do that redacting as appellate judges. So what we're left with, so it must mean that there are some cooperative associations that with capital stock where it may not be appropriate to apply, correct?
It may mean that. That absolutely is correct. And I take your point very well, Chief Judge Gregory. And here's my response to that. The plaintiff has the burden of proof on that. The plaintiff filed the amended complaint. By the way, this is the third amended complaint.
I mean, I'm sorry to interrupt a little bit.
Okay.
Because I think that's an important question.
Yes, sir.
I mean, I don't think anyone doubts they have the burden of proof. We're talking about whether they've pled, and we're required to accept their allegations as true now. Right. So I don't think we're at the burden of proof standard. We're at the pleading standard.
I appreciate what you're saying, Judge Quattlebaum. And my point was going to be, after I said that in the amended complaint, if you're going to ignore the black letter law in this case, under Chapter 54, where my client was incorporated, states clearly and plainly, if you have capital stock, the Business Corporation Act applies. If you are filing a complaint where you were going to ignore 54-142 and proceed directly to 54-142, there are no allegations, nothing pled in the four corners of this complaint for the 12B6 standard that would have told Judge Dever why Mr. Shipman believed it was inappropriate to apply the Business Corporation Act.
Well, he's saying all these reasons. There's a lot of things he's talking about how the times and the economic realities and the circumstances pertaining to the industry have dramatically changed. And he says those things make it inappropriate. And I don't know if that's true or untrue, but that's what they've pled. So they've pled some facts. And so, kind of what are we to do with that language?
The same thing, Your Honor, that Judge Dever did, which is he had to make the determination in the absence of legislative intent, legislative history, or case law. He had to make the determination under all the circumstances in this case, what was the North Carolina Supreme Court most likely to do? Apply the BCA or the Nonprofit Act? And he did the proper analysis. And the point that I was trying to make is, if it's your position when you come into the complaint, and again, this isn't a traditional 12b6 first complaint filed in a lawsuit thrown out. The original complaint was filed in 2012. We were all here before this same panel on the $24 million settlement that got reversed. And then we came back, and after you remanded the case, a third amended complaint was filed. So Judge Dever, this is not Judge Dever's first look at this record. It is also not Mr. Shipman's first attempt to get the facts right. But he ignores in the complaint 54-142, and he goes directly to 54-142.1 with no allegation that Judge Dever could take in light most favorable to him as why it would be inappropriate to do what the North Carolina legislature said.
Whitman, you teed it up very well. You triangulated because you said the district court would have to look at which of the two statutes would apply. But the connector to that triangle is this language of how did the district court resolve this when appropriate aspect of it? Because there's one like, well, what the Supreme Court, North Carolina might do here and there, but aren't you delving in some degree of fact finding to make that determination whether or not this case has they've pled that they're different, but is it a factual question? Perhaps there's whether or not they in fact are valid, appropriate reasons why we should not apply it to them.
Respectfully, Chief Judge Gregory, in this case, I submit to you that there is not, because Judge Dever did what he was required to do in the Iqbal standard. He looked at the complaint, which is the third time these plaintiffs have attempted to file a dissolution claim under the wrong statute. He accepted the facts. You talk about factual disputes. He accepted the facts in the light most favorable to the plaintiffs, but then he concluded that even under those facts, as alleged, there's no plausible claim stated. And this is important. Under either the Business Corporation Act or the Nonprofit Act, Judge Dever could have just stopped when he did the analysis and said, I find that it's most likely under these circumstances that the North Carolina Supreme Court would apply the Business Corporation Act. He could have just stopped.
It was, and you know the order better than me, so I may not be remembering it correctly, but it seems like as he did that, the primary reasoning was, I think something you began to talk about was that there were no allegations of misconduct by the co-op.
Yes, sir.
Is that then the way we look at as appropriate? Is that the way that the district court looked or as appropriate? I mean, we're right. If we were to give some meaning to that language, which I think we're required to do. Right. What is it? And it seemed like in the district court, it relied on the absence of allegations of co-op misconduct as opposed to general supply and demand, Adam Smith types issues.
Correct. Yeah, and I agree with you. Let me see if I can connect the dots for you, because I have read this order quite a few times, and I think what Judge Dever was going to, the issue he was going to, when he made the comment that there are no allegations of misconduct by the board of directors or the corporation, was the issue. He had already completed his analysis, essentially, that the Business Corporation Act would apply and not the Nonprofit Act. He had analyzed the facts under both set of statutes, under both, and that's important, and found even if 55A does apply, I don't find a plausible claim under Iqbal. Then he made the comment after that, Judge Quattlebaum, that said, and really dissolution is not the right remedy here. What does dissolution do under the case law? Dissolution is to address corporate malfeasance, something that the corporation is doing wrong on behalf of the shareholders or the members. And there is not a single allegation in this very thick third amended complaint that alleges that the board of directors did anything wrong. So he was making that comment at the end of the analysis. And if I could come back around to the question that Chief Judge Gregory asked and you followed up on, Judge Quattlebaum, I think in fairness, when you read the four corners of Judge Dever's order, essentially what he did, since we don't have any case law interpreting what the words "so far as appropriate" mean, we don't have any legislative history, we don't have an insight as to exactly what the legislature meant by that. He did an analysis of the facts that were pled, took them the light most favorable to the plaintiff, and found that there was nothing inappropriate about applying the Business Corporation Act's dissolution provisions to this cooperative. And I think the legislature sets the bar pretty high. And this goes back to the initial point I was trying to make. If you're going to come into federal court and make the allegation or take the position, and this is where I was going on the burden, Judge Quattlebaum, I certainly understand what you were saying. There's nothing in the complaint, the four corners of the complaint, which is what is evaluated on inappropriate to apply the Business Corporation Act. They just ignore the legislative direction in 154 in 142. It's ignored.
What about the allegation that, because that's why I'm saying it's beyond misconduct or any questions like that. They're saying that they can no longer fulfill the mission. Right. There could be reasons beyond their control. The market is different. Conduct malfeasance or incompetence is a matter of the times have changed and it's time to give this gig up and we need to dissolve it. So how do you resolve that the district court, not you?
Yes.
How are they able to say that's not, it would be inappropriate? So
I have two responses to that, Your Honor, and I'll answer the most immediate one first, which is Judge Dever did exactly that. He looked at the complaint and he essentially said, the only basis upon which the Third Amendment complaint proceeds is 55A 1430E, which is what Your Honor just mentioned, that you're not fulfilling your corporate purpose. He looked at that very close, and he found two things that are very salient for this court's consideration. First, the entire foundation for the plaintiff's argument on that was relying on the wrong statute. Judge Dever did the analysis and he draws back every allegation that Mr. Shipman's client made with regard to not fulfilling corporate purpose was really under 54-129. Now, and this is important. Details matter. 54-129 is policy, legislative policy for Chapter 54. And Judge Dever makes this point. 54-132 is purpose. So what does the language in 55A 1430E say? It says you're not fulfilling your purpose, not policy, purpose. So the complaint is completely alleges the wrong standard on multiple levels. It uses the wrong standard for dissolution. And even when you analyze it under 55A, is the corporation serving its original purpose? They don't go to the allegations in 54-132 with regard to purpose. And Judge Dever talks about that. There's a reason that they don't do that, because if you read 54-132 purpose in connection with 54-151 powers, in connection with our articles of incorporation, it's a very broad grant of power and purpose to this agricultural cooperative. And the second piece, I said I had two answers to this, Your Honor, and I do bring it up because this is not your typical initial complaint filed, 12B6 motion granted. We are 10 years into this thing. It's 2022. Mr. Shipman filed his first complaint in 2012. But remember, when we were here to see you guys a couple of years ago, Mr. Shipman was supporting a $24 million settlement of that case. And in reaching the order that he did, Judge Dever, that $24 million was reasonable and fair for the class, he had to analyze Mr. Shipman's claims. And guess what he analyzed? He analyzed that claim under 55A 1430E. And what did he say? Judge Dever said, and this is in docket entry 267 on page 56 of Judge Dever's order. He says, quote, as for subsection E, the cooperative's articles of incorporation permitted to engage in, quote, any activity involving or relating to financing, marketing, selling, and or distribution of the flue-cured tobacco, period, close quote, articles of incorporation. based on this court's extensive review of the record, the cooperative is still actively carrying out its purpose. Now, that was in his order, an order that Mr. Shipman and his clients were supporting at the time. And Mr. Shipman knew that finding had been made when he then filed a third amended complaint, still alleging that the corporate purpose wasn't being served. This same judge, Judge Dever, then analyzed that claim again. And to Judge Dever's credit, he did not reach back into the evidentiary record from the class settlement. He analyzed the allegations in the third amended complaint and only the third amended complaint to conclude under Iqbal that even if you take the facts pled in the light most favorable to the plaintiffs, it doesn't state a plausible claim. Because when you actually distill the allegations, and there's a lot of them in that complaint, Chief Judge Gregory, you can see, and Judge Dever identifies them in his order, how he actually alleges that the cooperative is serving its purpose. It is serving its purpose. It is serving its members. We do act cooperatively. Mr. Shipman's complaint uses claims that we're not acting cooperatively, and that's a misstatement of cooperative law. We act cooperatively with the members that we have to market, sell their flue-cured tobacco for the benefit of them as active producers of that agricultural product. We do act cooperatively. We continue to act cooperatively. We serve a very vital function for these farmers. Everything that Mr. Shipman alleged about the industry is true and was taken as true by Judge Dever. It's very, very hard for tobacco farmers out there. And even though that's the case, Judge Dever finds in the allegations made by the plaintiffs that there is no plausible attack for dissolution of this cooperative on the facts alleged, the facts that are undisputed. This cooperative is serving its purpose, is more essential than ever to the flue-cured farmers that are still able to put that crop in the field, that our cooperative offers the services that it does. And again, Judge Dever could have reached back and said, in support of the dismissal order I'm issuing, look, I did a full evidentiary review of substantive evidence and depositions and affidavits, and I already found that it's serving its purpose. But he didn't do that. He did what he was supposed to do. He followed the 12B6 protocols. He followed the standard of review. He took the facts in the light most favorable to the plaintiffs that alleged them, and he determined. And like I said, he didn't just stop when he concluded that a Business Corporation Act applies. He said, let's look at the allegations under 55A, because even there, based on what's pled, I can't do anything but conclude it's not plausible to conclude that this cooperative is not serving its purpose. And that's huge, because we know what the district court judge was thinking now. And based on those two analyses that he did, he then dismissed the declaratory judgment rule. And that's pretty straightforward black letter law in this circuit, that the judge has the discretion to do that, especially given that under the Declaratory Judgment Act, there's no substantive right. Those declarations have to be attached to a separate substantive claim. So, Your Honors, for all of those reasons, the reasons in our appellee's brief, the reasons that we've discussed in oral argument, it's our respectful request that you affirm the decision of the district court to dismiss the third amendment complaint with prejudice. Thank you.
Thank you, Mr. Whitman. Mr. Shipman, you have some time.
Please the court. Might I remind the court, this was a supplemental pleading setting forth the matters that had occurred in the tobacco industry since 2012, and much had changed, not only in the industry generally, but with this cooperative specifically. As appropriate, the North Carolina legislature.
But you do include paragraphs in the complaint at JA 143 and 144 at least, that indicate that the cooperative was serving the purpose of the cooperative.
Until the end of price support, it was, because the only way you could get flue-cured tobacco.
Is that still in your complaint?
Well,
your supplemental complaint where you updated everything?
I'm sorry, was what?
But the allegations that are at JA 143 and 144, that's still in your complaint.
In our supplemental complaint?
Uh-huh.
Okay. Do you have a paragraph? I don't have the actual, I've got the complaint.
Do you disagree that there are places in the complaint that indicate that the cooperative is serving its purpose?
No, ma'am. We have fundamentally stated that it's not serving its purpose. Look at the Jones case as to what the North Carolina Supreme Court said 100 years ago. There is certainly, they are providing a market, but as the Jones case said, they must be able to act cooperatively to control prices, to provide a market. That's why they have antitrust protections, that they have the ability to require all of their members to sell their product only through them. That's traditionally the way agricultural cooperatives do their business. Egg cooperatives, butter cooperatives, milk cooperatives. Everyone must sell through us so they can control prices. And as the authority that we have cited in our brief makes clear, if they do not take production from all of their members, they cannot control prices. And contrary to a suggestion to the contrary,
Paragraph 82 on JA 144, that paragraph seems to list a number of things the cooperative did in an attempt to achieve the goals of the cooperative.
yes, ma'am. Prior to 2012, when this action was filed, those actions had been undertaken post FETRA with the proceeds, if you will, granted to them by congressional act. So yes, this complaint details the efforts that this cooperative have made. We're not alleging misconduct. That's back to the point. We have just stated that despite their best efforts, they are no longer acting cooperatively, and therefore it is not appropriate to apply the provisions of the North Carolina Business Corporation Act to a claim for dissolution by stockholders when members of a cooperative are not stockholders and do not have rights as a stockholder.
But counsel, I think, and what you just said, you had opportunity to refresh my memory looking back at the district court's order. It looks like what the district court said is that you have allegations, about how the co-op is no longer able to serve or further its purpose. We can debate whether those satisfy that standard. I hear you on that. But what it looks like the district court says is your arguments for why it's not appropriate really, fundamentally amount to your claim that the structure of a co-op is different than the structure of a for-profit corporation. Members versus shareholders. You were just talking about that. And it seems like the trouble with that argument, maybe as appropriate has to mean something, but it can't mean that the structural differences between a co-op and a for-profit entity are define what's appropriate or not, because that really would erase the with or without capital stock.
And I agree with you. And that's why we have pled the market conditions that currently exist. That's why we have pled the traditional differences between a business corporation and a cooperative, that you're not acting cooperatively now anymore. You're acting selectively. They're acting like a business corporation. So I think what you've got to do is apply the facts as pled to determine whether it is appropriate. The structure, it is not a one-size-fits-all decision about whether to apply the Business Corporation Act or not. There is no bright line, contrary to suggestion by counsel, for the cooperative. If it was that clear, the legislature would have said so. What we're contending is in light of the current situation faced by this cooperative, where they no longer can control prices. You look at what the Jones case says to be the purpose behind, and one of them is to control prices against big tobacco. Judge Gregory, I sense you had a question.
Listen, I was thinking about your argument about that. And this is a naughty case, and it's no question about it. But it seems like what you're talking about is sort of, the statute is sort of the gatekeeper, like telling you which way you go, one way or the other, based on who you are, not what you want. And it seems like it's a conflating of, but if we get inside, it'll show you how we're different, because as you said, It's not their performance, it's that the market has changed. But for statutory purposes, we got to first decide which way you go and what's the appropriate, whatever it means, it must be appropriate based on who you are as opposed clearly as the details, because then that would be the tail wagging the dog, because then you get in there, oh, this is what we need. Oh, then it's appropriate. You see what I'm saying?
Yes, sir.
The problem is you have to sort of stage this, get into the door first. You can't say, well, if I can get in there, I'd have the key, I'd be able to open the door. No, you got to have the key before you open it. You see what I'm saying?
The final point, and I'll sit down, and I appreciate it.
But no, but I want you to drill into that, because I think that's important. At least I think that's important.
Well, that's why we point out the differences between the rights of a member of a cooperative. They're not freely transferable. They can be redeemed for $5. And the rights of a shareholder. You can't win the purpose, and you must accept that as true, for which this cooperative was formed no longer exists. You can't apply what appear to be issues of misconduct or issues of lack of investment-backed expectations. You can't apply that to a agricultural cooperative whose purpose no longer exists through no fault of their own. Thank you.
Thank you. Thank you so much. Thank you both, counsel. Thank you both. We would love to come down and greet you in our normal Fourth Circuit traditions, but you understand under the conditions we can't do that. But please know, nonetheless, we very much appreciate your arguments and being, as I said before, these thorny issues. We appreciate you helping us on that. We wish you well, be safe, and thank you so much.
Thank you, Judge Gregory.
All right.
Thank you. Now.
You may proceed.
Good morning. May it please the court, Jonathan Fazzola on behalf of the estate of Naji Ali Baker. I'm honored to be here today, so your honors are aware, with Ronald Baker, Naji's father, and he wanted to make sure I extended to you his gratitude for hearing this case and giving us oral argument so his family through me could be heard. So we appreciate that. Wake Forest knew and was on notice that fights, brawls, and escalating violence were regular features of late night barn events dating back to when the barn opened in 2011. Despite that well-documented and lengthy history of violence, in late 2014, Wake Forest slashed on-site security for barn events to a single police officer stationed outside the barn. Wake Forest was repeatedly warned and knew that the one officer plan was unsafe and irresponsible. Wake Forest hired hands-off security, wanted its own hands-on security for when fights broke out. Student hosts repeatedly begged Wake Forest to let them hire their own or additional hands-on security, such as bouncers for barn events, specifically to keep fights from escalating. Wake Forest's own police chief advanced a recommendation to bring back Winston-Salem.
The fact that this was outside the barn and involved a shooting, and there'd been no shootings on campus in the modern era. What does that do to your foreseeability argument?
Well, and thank you for the question, Your Honor, or I guess two questions. The fact that it was outside the barn, it has no difference in terms of foreseeability because those prior events that had broken out and escalated in various down the roadway and into the parking lots. And Wake Forest knew and understood that that was the environment, the specific corner of campus where the risks of altercations at the barn would be located. We know that based on their own diagrams, based on their prior reports, and based on the fact that Officer Bottoms on the night in question, when he came out of the barn with no idea what was going on inside, but had zeroed in on one individual who he decided he needed to make sure to de-escalate the situation and have him followed down the road. When he radioed for backup, he didn't ask them to come to the barn. He asked them to report to Lot W, where he knew and understood that's where the attendees of the barn event were told and directed to park. As to no prior shooting, the case law and the rule in North Carolina is clear through Foster that through the exercise of reasonable care, Wake Forest only needed to have foreseen that some injury would result from an act or admission, or that a consequence of a generally injurious nature might have been expected. That's precisely what the prior events, but also the direct warnings that Wake Forest received before the event on January 19th, 20th, 2018, gave Wake Forest actual direct and construct knowledge of. That's why the rule used by the district court, which was basically the rule advanced in the dissent of Foster, of a high degree of recent similar criminality, is just not the law in North Carolina.
Mr. Basil, you in response to Judge Thacker's question, and understand you said the scope of concern, if you will, based on past events would be beyond, I think you're dealing with to include the parking lot. But is that scope the same scope you said that if they had had the, as you say, appropriate number of police officers, would it have how far would that have extended? A mile from it, or what? The parking lot? What would be the terminus of what you say? Because as you know, we're going to get down to proximate cause and
of course
beyond that kind of thing. How large is that area that policing would have included? That you say reasonable policing would have included?
Well, and it's a great question, Your Honor, and I don't think we specifically called this out in our brief, but if the record shows that the roadway that we talk about from the barn, the single roadway that was effectively put there just to get to and from the barn, was about 300, 400 feet long, no more, no less. So not a large roadway we're talking about. Parking lots there were two parking lots, LIU and W, just off that roadway. And then from there were gatehouses, which per its policy and practice, Wake Forest had IDs or had attendees coming to barn events, check their IDs. So that's the specific area of the campus in which the risks of fights escalating from barn events and occurring and breaking out was foreseeable to occur. That was the general environment where they had occurred in the past. And that was the general environment when fights broke out, when police officers were at the barn, they'd radio for backup to Lot W, to the roadway, because they knew and understood as the crowd is moving away from the barn, and if there had been violent episodes, that's where they could continue to erupt and spread. Vice President, sorry, Your Honor.
The reasonable foreseeability of things escalating, fights escalating to the point of a shooting on the roadway outside the barn?
The reasonable foreseeability is they knew that there'd be fights that could escalate. Fights can escalate in a variety of ways. They had escalated at previous events for someone to be beaten unconscious to the extent they couldn't talk, had to be transferred.
So and that incident when someone was unfortunately beaten unconscious, that was in the pre-DOS plan era, right?
Sure, if we're going to draw
that
that way,
was
correct.
At a time when the barn was, in the view, I think, of appellant, more heavily policed, right?
That was, Your Honor. It was also at a time where there were some overcrowding and capacity issues. But the nature of the risk of fights escalating and people, I mean, the individual that was beaten unconscious, it happened right near the exact, almost the precise spot where Najee was shot. He was followed down by Palmer and Piccolo.
At a time when it was heavily policed in the pre-DOS era, correct?
Correct. And even that heavy police force, because of the nature of the brawl at that particular event, you know, Chief Burke had warned when he went and consulted, when fights break out, each fight deserves an officer's attention, and the less officers on site, the less officers there to dedicate that attention to those fights to address them. And once an officer's attention is distracted by one fight, you have a less on-hand security to address others that may break out. I mean, it's precisely as the sequence of events played out on January 20th, 2018, what happened with Officer Bottoms. He went in, didn't know the identity of the combatants, got distracted by a male in a black tank top, used his reasonable police judgment to say, this young man looks kind of heated and out of control, and I need to tell him to chill. He told him to chill, and he testified that he did that to prevent things from escalating. He understood the importance of that, and he also understood the importance of following and having a police officer follow that young man down the road. Fortunately, it wasn't he hadn't zeroed in because he didn't know on the individuals that presented the most heightened risk of harm that night, Shakir Austin and Malik Smith, because he didn't know they were the initial combatants. He didn't know that Malik Smith, for example, had no right to be in the barn in the first place. And he didn't know that Mr. Willie, a WSU employee and student who was standing outside the barn, heard a group in which one individual said, go get your gun, pull it out, go get it. Testimony from police officers that we deposed from Wake Forest clarified that if they had heard that, it would have immediately signaled to them a potential immediate threat to public safety, would have required an immediate police response, would have required them to call backup, search for the individual who might be going to get his gun, maybe detain him, question him, and make sure he wasn't a risk. That didn't happen. And if your honors, it's kind of a dance. But if you look between Officer Bottom's video camera and which is I think DMJ4, in the video of the first Shakir, then Malik, then Najee, then the individual with the tank top, and then Officer Bottom's leaving the barn, there's a reasonable basis to infer that Mr. Willie may have seen the extra scuffle and then heard, go get your gun, approximately 5 minutes before a gunshot rings out. He sat with that information with his hands in his pocket because he was untrained and he was unprepared to fulfill his responsibility, which Wake Forest had given him, which was to identify risks, this is his testimony, and report them up. Armed with the knowledge for 4 or 5 minutes that someone, after a fight inside the barn, escalation outside the barn, someone said, go get your gun, pull it out, go get it, sat there with his hands in his pockets, didn't convey that information to police. So when Officer Phelps goes down the road, her police lights are off. There's absolutely no urgency. And if you watch Officer Bottom's body cam, he ends up walking down the road after the gunshot is fired.
The issue of causation, how are we to square the fact that on the record here in all the incidents you cite to, more incidents occurred at the barn before the DOS plan was implemented than after?
In terms of causation, we would say after the DOS plan, Wake Forest was on notice that the features of that plan presented a specific, unique risk that when fights broke out, there'd be less on-hand security to address it. And that meant when they did break out, they could escalate more dangerously than they even had in the past. An important piece of that.
So, Council, I want you to finish Judge Thacker's question, but I just want to make sure I understand it. You're saying that even though their experience with the new plan results in less incidents or fewer incidents and incidents of less severity, that shouldn't affect their foreseeability?
Well, first of all, Your Honor, we wouldn't necessarily concede that it resulted in less incidents. Again, we think there's a material dispute of fact on that issue. What we would say is, there's a discussion of us making artificial line drawing. In her declaration, Chief Lawson says, after the university started implementing Chief Burkhead's recommendations, things didn't get better, right? But if you look at the data on that, there were only fights and altercations at about 11% of events. Now, there was a short time period, sure, but that's because Wake Forest quickly abandoned that plan and moved to its one-officer plan. But the reason that's important is there's a reasonable inference to be drawn that the improvements that were seen at the barn were the result of Burkhead's recommendations, which were introduced, and then perhaps a relaxation of the student ID policy at the door, which may have reduced the jam at the door and may have reduced some of the pushing and shoving. But what it did is it let more as
the person that was convicted of the shooting actually have a valid student identification.
He testified that he did, that he wasn't an active student at the time, but that his ID was not had not been revoked. So he said he was carrying it.
So if somebody looked at it at the door, it would have appeared valid, at least, even assuming it should have been revoked.
Assuming potentially, but his compatriots
wouldn't have changed anything.
Well, it would have, because
at least with respect to the shooter and his ID.
With respect to Jakir Austin, that's correct, Your Honor, absolutely. But his compatriots were not college students; they didn't have college IDs. And remember, the initial big old brawl, as Jakir Austin described it, didn't start between him and Najee. It involved Malik Smith, who should have never been there, didn't have an ID, and wasn't a college student, had no business being in there. And so to get back to my point about the ID, Wake Forest was on notice as officers testified that when non-students came, it increased the risk of criminality. And, Winston-Salem Assistant Police Chief Miles, I think she said, when non-students come, they bring trouble. And so effectively, the new plan said, we're going to throw open the barn doors to increase criminality. We're going to go 50-50 on that. And then when there's interior fights breaking out, we're going to leave it to students who themselves, the student hosts, are telling us, we need bouncers like in a bounce club or like a dance club. We don't feel safe diffusing these fights. And there's evidence that they were disinclined to go get the single officer outside the barn because they didn't want the police coming in, which further compounded the dangerousness of the one officer plan. I see that I'm over my time. And
I want to ask you a question before you go. It's not going to eat away from your rebuttal time.
It's fine.
But I want you to respond before your colleagues on the other side address the court. Getting back to foreseeability, take you back a little back to law school, first year law school. And for your memory, should be a lot better first year than mine is, because it's a whole lot more years ago for me. But, I think wagon bound type thing where I think it was one or two where the danger, the foreseeability was that a fire might occur. But there was actually remember the case was actually a freak way that it happened. And basically, it doesn't matter that the fire occurred. The fire didn't have to occur the way it happened. It's not necessarily foreseeability that how it happened, but that it might be a fire. So you don't have firearms, as you said to the court in terms of past. My question is this. So then it seems to me you'd have to have some kind of level of severe type injury, or at least that would be important to the case. Do you have any evidence that someone was hospitalized, severely injured in any of these brawls? Because a brawl goes from, none of which are correct, mind you, but pushing, shoving, yeah, you get out of my face, and that's a brawl. Right? But is any evidence of injuries, hospitalizations, or someone unconscious, or whatever in this record?
There's the individual who's beaten unconscious, could only moan, was taken to the hospital. There's the individual.
2012.
Yeah. Correct, Your Honor.
And then talk about, prior to.
And then there's the incident of the young woman being trampled by the crowd, and when she's being transported by Wake Forest Police Department, saying, I don't feel safe here at these barn events with all these non-students. And while she's at the hospital, she overhears another barn attendee who had a gash on his head and was hospitalized, saying he had a gun pulled on him at the barn.
Okay, and the unconscious incident was in 2012 before the DOS plan. When was the young lady trampled? When was that?
That was also prior. Your
Also
Honor.
before the DOS plan.
That's
Right.
the November 13.
Correct.
Okay.
But again, those revealed the risks of fights breaking out and escalating outside of the barn. She was trampled outside of the barn, and the purported gun that was pulled, I believe, was either as the crowd was moving out of the barn or in the grassway of the barn. And after the DOS plan, we saw incidents again and again that showed when fights broke out, they'd escalate. ERMs got punched in the face, pushed in the door, etc.
Are there any after the DOS plan, in answer to Chief Judge Gregory's question, where hospitalizations were required?
Not in the record, no, Your Honor.
Well, other than, okay.
Thank you.
And I appreciate that. Thank you.
Good morning. May it please the court. My name is Robert King. I'm with the Brooks Pierce Law Firm in Greensboro, North Carolina. I represent the defendant appellee in this matter, Wake Forest University. I'm joined at council table by the Deputy General Counsel of Wake Forest, Ms. Dina Marty. I appreciate the opportunity to be here. If it's agreeable to the court and time permitting, I'd like to address 4 topics and would like to give the court a quick overview of what those are. First, it occurred to me as I was preparing for this hearing that we really did a poor job in our briefing in describing to the court what is meant by reasonably foreseeable in this context. And as I will explain to the court, what that means is that this type of crime or something similar to that was likely.
Not in your brief, you can't argue it. So.
Well, then I'll move around some, Your Honor. I mean,
I'm not trying to stop you, but you know that's the rules. You can't, you didn't brief it, but go ahead.
Well, I understand, Your Honor, and here's my point on that. Everybody agrees that the standard is that the crime or something similar to that is likely, and what we really did not expand on is what likely means in this context. Second, I'd like to talk about why the plaintiff's basic argument is wrong. Plaintiff's basic argument is that fistfights in 2012, 2013, and early 2014 made a fatal ambush shooting outside the barn likely or highly probable to happen years later. Third, I'd like to address the 2 alternate theories that the plaintiff has come up late in the case to try to avoid the problems that they have with foreseeability. I will also add that of the 5 things that the plaintiff was required to show evidence of at summary judgment, existence of a duty, breach of a duty, existence of a duty, contours of the duty, breach of the duty, proximate and actual causation, and damages, they showed 1, damages. We have been asking from the beginning of the case, what was it that you say we were supposed to do that would have prevented this shooting? Standing here on March 10th, I still have no idea what the answer is because plaintiff failed to come forward with any evidence on that. So plaintiff's 2 alternative theories are voluntary undertaking, sometimes they call it negligent undertaking, never been recognized in North Carolina. That theory under a different label has already been rejected by the North Carolina Court of Appeals. That theory with that label has been rejected by this court in the Durden case. And then what I jumped ahead to, the fact that plaintiff in fact failed to present any evidence at summary judgment of what the duty was, how the duty was breached, or what it was that Wake Forest supposedly could have done to have made a difference. So what do we mean by reasonable foreseeability? Plaintiff themselves quote the correct rule, quoting from Murrow v. Daniels on page 24, in fact, of plaintiff's brief. A landowner owes a duty to exercise reasonable ordinary care to protect his patrons from intentional injuries by third parties when the owner has reason to know that such are likely to occur. Not that the injuries might occur, because as the North Carolina courts have said, in some respect, all crimes are foreseeable. I could walk out of here and be shot in front of this building. That's not the standard. The standard is very difficult in North Carolina. Likely means if you pull out a dictionary, and here I pulled up Merriam-Webster, having a high probability of occurring or being true or very probable. So in order to get to a jury, the plaintiff must present evidence that the crime in question, the ambush shooting of Mr. Baker, was something that was likely to occur or highly probable to occur based on the fact that there have been fistfights that mainly had occurred several years before.
So counsel, on that point, assume for the sake of discussion that you have a strong argument about the events in the years leading up. What about the day of the incident, the day of this accident, when there's comments that a Wake Forest security official heard that, get the gun? I don't have the exact language, but and I can foresee issues with that. related to breach of duty or causation, but how does that not at least create some foreseeability on the day of the event?
Thank you, Your Honor. Great question. That was in my outline, and I'll go ahead and address that. First of all, the evidence in the record as to the time difference between when this student employee heard this and when he heard the gunshots was 2 to 3 minutes. That is a late blooming theory. It is not in the complaint.
Well, that might get to whether if they did something, they breached the duty, and it might get to causation, but stick for the moment with foreseeability. When a Wake Forest security official apparently hears go get a gun and decides it's not really a real threat.
Okay, and I will do that, Your Honor. First of all, as I was mentioning, it's a late blooming theory. It's not in the complaint. It's not mentioned at all by their expert because their expert didn't say anything about it. Our experts didn't say anything about it. We started dealing with this issue in summary judgment after the close of discovery. But let's be clear about what was said, because that theory makes absolutely no sense. What this person overheard was not, I've got a gun, I'm going to go get a gun, or he's got a gun. It's one person walking away from a building, yelling at some guy down the road, go get your gun. Well, by definition, nobody had a gun. So what was it that somebody was supposed to do? Was a police officer supposed to run and grab this person and say, why did you yell that? Well, I thought this guy might have a gun. Go grab that other person. Do you have a gun? By definition, he didn't have a gun. So we're talking about this theory that was never raised before summary judgment. There's no evidence in the record, no suggestion by plaintiff as to what should have happened. And I think that goes to the foreseeability and to the issue of breach of duty. I want to go back, if I could, for a second to the foreseeability issue, because it is important to consider, I think, how tough the North Carolina law is on this. I have read every case in this topic or in this area. These cases go back to 1934, Ward versus Southern Railway, and I'd like to talk about that case for a second. In 88 years of jurisprudence, North Carolina appellate courts 5 times have ever said that a plaintiff presented evidence of foreseeability and proximate causation sufficient to get to a jury. That was a shopping mall with a long history of similar violent crimes, a bus station with a long history of violent crimes, and 3 motels in high crime areas with long histories of crimes. In our situation, Wake Forest has got to be one of the safest places in North Carolina. In 63 years, we'd never had a homicide. We'd never had anybody use a firearm for anything. We had never had a crime anywhere remotely near this. The record, counsel wants to speculate about the idea that maybe there's a factual dispute about whether or not things improved over time or not. They did improve over time, and there's nothing but speculation on the other side that it did not improve over time.
Counsel, is that our lens, that Wake Forest as a whole, or should, I think your colleague would say maybe generally that's true, but the lens should be at this barn rather than the school as a whole. So I'm not saying who's right, who's wrong, but I'm pretty sure that's what they would say to that. What's your response to that?
Well, I would start with saying that the plaintiff gets to frame the issue in the complaint. And if you read the complaint, this is a complaint about campus security. It is not a complaint just about the barn. Let's say it's just about the barn. Never been a homicide at the barn, never been a fatal shooting at the barn. And here's the thing that really, this whole thing about we've had these fights and things might escalate, I think that actually hurts plaintiff's case. And here's why. The argument is fist fights make it foreseeable that someone's going to pull out a gun in the heat of passion and shoot somebody. Well, first of all, that's not what plaintiff says happened. What plaintiff says happened is that Najee Baker was calmly strolling to his car when he was ambushed. So this whole idea that there was a fist fight and somebody became enraged and pulled out a gun is not in fact what plaintiff themselves says happened. Second, the fact that there have been fights on campus and none of them ever resulted in this type of injury kind of proves our point. Look, Wake Forest has had a campus here for 63 years, and where there are colleges, there are college parties, and where there are college parties, there are overheated young men. Where there are overheated young men, there are fistfights. We've got 63 years of college people doing the things that I did and other college people do, and nobody ever pulled out a gun. Nobody ever had a gun. Nobody ever got murdered. You talk about data points. That's 63 years of that. And let me mention this. I've been struggling with this idea of how to put the incredibly unprecedented nature of this into arithmetic terms or mathematical terms. And I came up with this idea of the visitor day, sort of like a work day. One person on the campus, one day is one visitor day. If you take the number of days that this campus has existed prior to the shooting of Mr. Baker, multiply it just by the number of students, faculty, and staff, forget people coming to parties, forget visitors, forget vendors, you have 500 million visitor days before the shooting where nothing remotely similar to this happened. If I roll the dice 500 million times and it comes up snake eyes every time, it is not foreseeable that anything else is going to happen. So this idea that fistfights turn into shootings is rebutted by the actual facts of this case. I'm going to mention two cases. I mentioned there are only 5 cases in the history of North Carolina jurisprudence, and they're all terrible cases. The lesson there is don't go to motel parking lots at 2 o'clock in the morning, because that's what most of these cases are about. Let me talk about 2 cases where the court said there is not foreseeability, that are pretty remarkable cases to me. And the first one is the granddaddy of them all, or the grandmother of them all, Ward versus Southern Railway. 1934, for 30 years, people had been climbing on coal cars and throwing chunks of coal over the side, which was a crime. They were stealing coal. The railway knew it for 30 years. Somebody throws a piece of coal off, and this particular time it hits a brakeman on the head and kills him. The brakeman's family sues the railway, and the Supreme Court said, yes, this criminal activity had been going on for 30 years, this exact activity. Yes, the railway knew it was going on for 30 years. No, it was not foreseeable because nobody had ever been hurt. The other one I'll mention to you is Purvis versus Bryson Jewelers, which happened in my hometown. Purvis versus Bryson Jewelers was a situation in which somebody was injured during an armed robbery at a jewelry store. There had been...
In that case, you think it may have been a difference that it was trespassers who were the tortfeasors, third party, as opposed to invited guests to the barn in a regular type event that the school quasi-sponsored by allowing it?
No, that's a great question, Your Honor. The law in North Carolina prior to 1998 was that there were different standards for trespassers, but that was if the trespasser was the plaintiff. It was the duty owed to the person. So the standard of care in 1934.
Can you tell me that being responsible for a third party's acts, the fact that the trespasser would not factor into that analysis?
Not based on any of the cases that I've read, Your Honor. Because the issue is not whether these people were trespassers. The issue was whether or not the railway knew that this activity was going on, that this criminal activity was going on. And what the Supreme Court said was, yeah, it went on for 30 years. Yeah, the railway knew it was going on. Yeah, the exact same thing happened that day that had happened for 30 years, but it was not foreseeable that someone was going to get hurt because this time somebody got hit on the head and it had never happened before. The Purvis case that I would mention to the court, jewelry store robbery. In the vicinity of the jewelry store, there had been 937 crimes and 24 armed robberies in the prior 3 years. Now, that sounds like a foreseeability situation, and the Court of Appeals said that was not foreseeable because none of those happened at a jewelry store. That's the standard in North Carolina, and that's why we got 5 cases in 88 years, and all of them are egregious situations. The Wake Forest situation could not be any more different than the 5 cases where the court has found foreseeability. I want to cover that. Oh, here's the other thing I would mention on foreseeability. We have to keep in mind how many security professionals had looked at the barn and considered security at the barn prior to the tragic shooting of Mr. Baker. Wake Forest Police had looked at it. Winston-Salem Police had looked at it. The Rhino security folks had looked at it. The Dean of Students Office had looked at it. Chief Burkhead had looked at it. You had all these security professionals that came in, they thought about it, they looked at it, they wrote about it. Not a single person ever said, I'm afraid there's going to be a shooting. Not a single person ever said, if we don't do this, X, Y, or Z, I'm afraid there's going to be a homicide. If it was foreseeable that activities at the barn were going to result in a homicide or a shooting, let alone an ambush shooting, why did every single security professional miss that fact? I think I've addressed one of the two alternate theories. Plaintiff has put a lot of stock in this idea of a voluntary undertaking, although sometimes they call it a negligent undertaking. As I mentioned previously, that has never been recognized by North Carolina court, but in fact, it has been rejected by the North Carolina Court of Appeals, applying a different label. In the case of Urbano versus Days Inn, the plaintiff was attacked in a motel parking lot, as most of these cases are. One of the plaintiff's arguments was, and this will sound familiar to the court, that the motel said to the public, we are providing security and our property is safe. That is exactly what the plaintiff is trying to argue here. Now, in the Urbano case, the label that the plaintiff put on it was implied warranty. It's the same thing that's being argued here, voluntary undertaking. And the North Carolina Court of Appeals said, no, because what you're trying to do is you're trying to get around the foreseeability argument. What you're trying to do is completely rewrite North Carolina law by making people guarantors. This is exactly what they said. Under our decisional law, an innkeeper or other occupier of property is not the insurer of the personal safety of the business invitees, period. This exact argument has already been rejected in North Carolina law. It could not be a more transparent effort to avoid the issue of foreseeability. I'll also mention that the Fourth Circuit, applying North Carolina law, has rejected voluntary undertaking in a wrongful death, not a wrongful death, it was an assault case, in the matter of Durden versus United States as well. I'd like to briefly touch on.
In your arguments that you regaled us in North Carolina law some 80-some years, would it be different if this happened in a dorm? Because you open the door by your extolling the history of the university in general, so you open it up. Would this be different if it happened in a dorm?
I don't see how, if everything else was the same, Your Honor, I think the answer is no. Because the issue is, what have we seen in the past? And none of the courts quite put it this way. But what all these cases boil down to is that when you hear about the crime, if your reaction is, yeah, I saw that coming, then it's foreseeable. 63 years, 500 million visitor days without something like this happen. I don't know how you can say that it was foreseeable that this was going to happen. Last thing that I would mention, because this court can obviously affirm on a summary judgment record on other grounds, plaintiff completely failed to provide any evidence at summary judgment as to what the standard of care was. They've never said, because here's what we expected when this lawsuit got filed. I thought they would bring in former chief of police from Tech State University who would say, I've done a risk assessment of this property and Wake Forest failed because they should have done A, B, and C. And if they had done A, B, and C, this shooting would not have happened. And of those things, plaintiff did none of them. Plaintiff did not provide an expert who had any knowledge about how campus security works. He said that how other colleges handled these situations was irrelevant. He didn't say what the standard of care was, and there's no indication of causation in this matter. What in the world was it that we were supposed to do? And the answer that we get in the briefing is, well, if you'd had more police officers, maybe one of the police officers would have been in the right place at the right time. I mean, that's just rank speculation of counsel. That is not evidence before the court. So if the court were to find foreseeability in this situation, there's no evidence of standard of care. There's no breach of the standard of care. There's no evidence of causation. I will close by saying, if I can find the right place in my notes, if this court were to reverse and find that Wake Forest could be liable in this situation, despite the fact that in 63 years, nothing remotely similar to this happened, despite the fact that this facility was repeatedly analyzed by security professionals, and not a single one of them said, I'm concerned there's going to be a shooting. I'm concerned there's going to be a homicide. The court will be massively rewriting North Carolina law. And what will be happening is that property owners will become guarantors of the safety of the people that come on their property. And that's something that the North Carolina Supreme Court and the Court of Appeals have been saying since 1934 is not the law. What happened to the Baker family is awful, and I hate to get up here and make an impassioned argument when I've got a grieving family across the aisle. It is awful what happened to them, but this is not the university's fault. I appreciate the court's time.
All right. Thank you, counsel. So you have some time.
It's categorically untrue that this case is about campus security writ large. Your honors have our complaint. We don't make it about campus security writ large. That's evidenced by the fact that when Wake Forest tries to attempt cite our complaint in their brief to make it a case about campus security writ large, they inaccurately quote and leave out key passages. The case has always been about. Yes, sir.
You can argue the case the way you want. You're up on rebuttal, but it might be helpful, at least to me, for you to answer this question to the breach. What standard of care and what's the evidence at this stage of breach of that standard?
And I really appreciate that question. You know, it's first incorrect that our expert, Dr. Kirkham, didn't provide a standard of care. Mr. King, during his deposition, didn't ask him about the central opinions in this case. The reason Dr. Kirkham opined that doing a campus-wide security audit wasn't necessary is because that's not what his opinions were directed at. His standard of care he articulates is having sufficient on-site security to respond, see, and intervene in fights to de-escalate them and to, without force, escort people off the campus. I'm a little shocked to hear Mr. King say he still has no idea what Wake Forest could have done. They could have done what they had been doing, what their officers' plans had shown. They could have been done what they did previously,
So you're saying that your expert established, let's say, in your view, that there was a breach of a standard. That would be the standard of staffing. Correct, right? Am I correct?
Correct. Although I will push back that in these cases, there is not a requirement that we establish standard of care through expert testimony. And I also,
I'm just trying to figure out what you do have. I didn't say that. I'm saying that is it correct that, forget about standard, your expert established a guidelines for staffing requirements, numbers of police officers, positioning, right? That's what you're saying?
No, he did not establish a guideline because his point was you could use various mixes of security. What was important, though, was to make sure you had officers inside to monitor risk. He offers an alternative, making sure that if you reduce the number inside the barn of officers, because you don't want too many because of student perceptions, make sure they have radio contact with outside officers or other security officials on the ground. That didn't happen here. Again, that would have been a way the inside people responding could radio out and say, we have people coming out that were involved in a fight. One of them's wearing a red hoodie. It's pretty easy to spot. But standard of care was articulated by the officers we deposed themselves by saying, for example, Sergeant Fisher recognizing the importance of having on-site security interior to identify, quickly respond to risks. Sergeant Gravely testified to that. And Sheriff Burkhead, who offered his recommendations, I mean, that's one of the reasons I'm surprised. What could they have done? Here are his recommendations. Officers inside, monitor potential risks. Enforce ID rule, no exceptions.
I think you've answered my question.
Right.
The next is on that is having, let's say, assume you did that. What about causation? It's a lot of layers in these kind of cases. What about causation?
There's a number of things that could have prevented this shooting that Wake Forest could and should have done. Again, if they had someone inside to monitor the risk and quickly identify the combatants, they would have been able to detain or not detain at least.
Did this fight spill into the parking lot?
It spilled.
You know what I mean by spill, right?
Well, it spilled outside of the barn and continued.
Did it spill into the parking lot? You know what I mean? Do we make it clear?
Well, yeah. I would say it spilled in the form of Malik Smith, who by Keandra Johnson's testimony ran to his car to get a gun to run back up the road, still operating under the heat of the moment. And if you were to believe Jakir Austin's testimony, he was quote unquote tripping and he was mad. There's no evidence to suggest a different motive for them to shoot Najee other than a continuation of the ambush that happened the fight that happened in the barn that escalated outside and that led down foreseeably down the roadway. And I do want to say, because my time is limited, Your Honors, the discussion about foreseeability that Mr. King keeps bringing up is just simply not the rule in North Carolina. You do not have to show a prior homicide to make a homicide foreseeable. And importantly, that's a foreseeability rule for circumstantial evidence. What's that, Your Honor?
You have to show that it's similar in some way. I take it that it doesn't have to be an exact match, but some similarity.
The lines the court draws are the crimes involving actual or threatened physical harm, Those are relevant to circumstantial evidence. And crimes that don't involve that, property crimes, robbing things from cars, that's the lines the courts have drawn. They've never said you need to show substantial similarity. That's the dissent in Foster. And again, that's under the circumstantial evidence test. We have direct knowledge of warnings. Mr. King brought up college parties. I've never been to a college party where I left saying that was a great party, but what could really use is some bouncers to make us safe. We also have evidence that Rhino Security wasn't aware that requests for bouncers were being made, and that those requests by the sorority never made it to the police force. The Chief Lawson, there's no evidence she was aware that the student hosts were saying we need bouncers to make this event safe.
Council, could I follow up a little bit on the discussion of the North Carolina cases? And I take to some extent at least your point about, criminal activity involving property versus criminal activity involving personal injury or bodily injury.
Right.
But does it matter that in those cases there is criminal activity? And again, I'm not meaning to condone fighting on campus, but is fighting on campus even, as it shouldn't happen, the same if is it criminal activity, and does that matter?
I believe it is criminal activity. Most importantly, it involves actual or threatened physical harm to somebody.
Right.
And that's enough to trigger. And again, that's the circumstantial evidence box, foreseeability under Foster. On frequency, I need to make this point if I can. There were 2 to 3 barn events a semester, 4 hours a barn event. Okay. Over 6 years. I'm not a mathematician, but if you do the math, that's about 12 hours of barn events each semester, which would be about 12 convenience store days, if we assume a convenience store is open, 12 convenience store days during the life of the barn. If you view the frequency of fights, altercations, both before and after the DOS plan against a matrix of 12 convenience stores days, if that frequency was happening at any convenience store in America, we'd all expect that they reevaluate what they're doing to make sure that their customers, unknowing customers coming onto their property, had sufficient safeguards in place. And with that, I see I'm over my time. I could talk forever, and I appreciate your honor's time and patience today. We'd ask.
Well, I took some of your time. I'll give you 2 minutes if you want to, because it was your rebuttal.
Okay, and I really do appreciate that, Your Honor. I want to say quickly, I'm going to go through the reason they want to make this a campus security case is those are the whack-a-mole cases, right? Random campus rape in a dorm. How are we supposed to know about that? Whack-a-mole, right? Random abduction in the corner of campus, not related to an on-campus event with a history of violence at a specific location with a history where it's going to be there at a limited time with a crowd of people. Whack-a-mole, right? Even motel parking lots. Who knows when the motel bandits are going to show up at any given time? That's a security whack-a-mole, And so we might, under circumstantial evidence, we want to make sure that there's, sufficient foreseeability there. Here we have an event in a specific corner of campus, specific time, with specific persons going to be there, with specific knowledge of the known risks. And it's completely different than a campus-wide security case, such as the one out of Louisiana, for example, where there's an individual sitting in the dorm and spontaneously out of nowhere stands up and shoots a young woman getting on the elevator. Those are the cases that are trying to make universities ensures of everybody's safety at all times, at all day hours. That is often not a fair burden to put on a university. But here, when you have direct knowledge and circumstantial evidence telling you we have barn events at a specific time, late night, and fights can break out and escalate, and you're being warned by your own hands-off security that they think you should have wands and you should have bouncers or bring back WSPD, and you're being warned by your own student host, including a month before the shooting where 4 fights broke out and didn't stop until it was down the road and the police could intervene. You have a duty to exercise reasonable care, to respond appropriately, and you certainly have a duty, we submit, if you've undertaken to do something that you're told is irresponsible and unsafe, to make sure you're exercising reasonable care in that undertaking. And finally, on that point, Castle does not foreclose a negligent undertaking theory against premise liability or owners of premises. Castle involved a private security firm in North Carolina. Is clear. Undertaken in those contexts is defined by a contract. Security firm had a contract. The contract did not require the security firm to intervene in the stabbing that was taking place. They were just supposed to be there to be a deterrent. So the court said it wouldn't be fair to impose on a duty here. They agreed to what their undertaking was, four corners of the contract. The court in that case did say, though, that the provision of the security by the hotel may be relevant to the, by the apartment, to the apartment's liability, but the court didn't need to decide that issue because the apartment wasn't a defendant, at least in that portion of the case. I don't know how much more time your honors are going to give me. I appreciate it.
It's red now.
Okay.
You got 2.
I apologize. I would just say as a final word, since you've indulged me, we ask that your honors reverse the district court and remand with instructions to set this matter for trial, and also with an instruction that the district court correct its opinion so that Najee Baker's name isn't confused with the name of his shooter. We thank you for your time and for hearing our case. Thank you.
To counsel all, we appreciate your arguments here today. We would love to come down and greet you in our normal Fourth Circuit tradition, but we can't. But know nonetheless that we appreciate all of you being here and helping us on this case. Thank you so much.
Thank you very much.
McDermott, when you're ready.
Good morning. May it please the court. Edward Patrick McDermott Sr. on behalf of appellant Terry A. Kogel. I'd like to start with the court's decision below on the motion to dismiss, where the court determined that the language of the EEOC charge did not provide sufficient notice for the employer. And in the standard here, under Chaco, Judge Wilkinson, and other precedents, is that where there's notice to the employer of the scope of the allegations, where the EEOC, in its reasonable investigation, would uncover this. If it relates, indirectly can relate, then that's sufficient. So the background is that we have cases where when people go to the EEOC, they don't check the box, let's say, for race, and then they allege a race claim when they filed initially an age case. This is an entirely different situation. If you look at the language of the charge, And in the language of the charge, Ms. Kogel identifies the exact acts that are acts of retaliation: the discipline, the discharge, the failure to accommodate. We have the same actors, the same time frame. It is wholly coextensive, but the box wasn't checked. I wasn't there. I doubt she filled out the form, but whether she filled the form out or not, there was sufficient allegation raised. I also think the record wasn't developed in making this decision. I understand how motions to dismiss are decided. But the reality is that we see that she communicated to the EEOC that she was retaliated against. We see in her communications with the EEOC that she goes over this retaliation. So obviously the EEOC had a retaliation case and they entertained it, if you look at that. Now, the court and some of the precedent has indicated that we should decide this on the face. So what we're doing was we're having a federal magistrate judge who, I don't know if was ever an investigator. I know there's one person in the room here that was a federal investigator. And I can say that you would sit down and say, what happened? Why did it happen? Why do you think they did it? Those three investigatory questions, maybe who to, and when. And you ask those questions, you're going to get what she told the EEOC when she communicated with them. And the employer was on notice. Counsel for First Aid will say why he believes they weren't on notice, and I'll be happy to rebut that. I'd like to move on to the accommodation. And here, if you look at the decision, the court confused the fact that Ms. Kogel was allowed to get her therapy, physical therapy, with the clear record evidence that she requested time off.
Okay, it's not clear to me what the requested accommodation was and where to find that. Did she request 4-hour work days so that each workday would be reduced by 4 hours, or did she request time off up to 4 hours per day as needed?
She actually asked that she be given time off to heal. And that's clear from the record. She says that she talked to Dawn Rowe, said, Dawn, when are you going to put me on the schedule for less hours? And Dawn Rowe didn't do that. She said she went and looked at her schedule. And that's actually in the record. It's not about the physical therapy. And what First Aid did, if you look at their argument.
So what does that mean? Less hours? Did she request 4-hour work days every day of the week, or did she request that she have reduced hours 3 to 5 days a week when she had appointments or pain or those sorts of things?
She asked to be taken off the schedule, reduced hours of work. And the indication from what she said in her deposition was she talked to her doctor, she needed to heal. She also needed therapy. Let's not confuse the two. There's something called the interactive dialogue in the ADA.
So just intermittent reduced hours whenever she needed for appointments or pain. That's what she requested, accommodation?
No. She said she wanted reduced hours to heal. Now,
well, I don't know what that means. Does she? That's what I'm trying to get at. What? Maybe you could just point me in the record to where the request for accommodation is that crystallizes what it is she asked for. I'm not saying that she didn't. I'm just trying to find. Yeah, I need a JA site. I know you're about to give me her deposition testimony.
That is correct.
But where did
excuse me.
Go ahead.
JA 593-594. Right. And the court in its decision decided that there was some kind of proactive obligation of Ms. Kogel, when in fact, under the Americans with Disabilities Act, when you say to your boss, I'd like accommodation, I want to be reduced off the schedule, the interactive dialogue begins. There's a duty to engage.
That's what I'm trying to find.
Okay.
Where the interactive dialogue began and
Okay.
what it was.
In the
we
court's,
can move
in the
on.
court's opinion, says, however, plaintiff argues that because her schedule was never proactively reduced, defendant failed to accommodate her request. I disagree. There's no proactive doctrine here. There's a doctrine of interactive engagement under the ADA regs. Once you're on notice of a disability, the so-called burden shifts to you as a manager of people to say, what do you need? By the way, we never got to that point. So if anybody would ever ask me, what exactly did she need? I would say, had her supervisor engaged in the interactive dialogue, we would know today, but we don't. But we know this. She says, and given this approval, this is Mr. Jelinek questioning, can you tell me how or why you believe First Data failed to accommodate this request for a reduced schedule? Because every day I went in and checked my schedule and it wasn't reduced. So she said she went and checked her schedule and it wasn't reduced. That's a concrete act, reduce my schedule. If you're asking me how many hours, my response to that would be, that's not her job. That is not her duty to specify exactly. It is her job to say, I'm disabled, I've been given this accommodation, and I need my hours reduced. And what Dawn Rose said to her was, you can't miss work. So that's where it ended.
Well, she did, okay, I found it. She did provide from her healthcare provider at JA 288 that she needed to work a reduced schedule, 4 hours per day, 3 to 5 days per week. So she provided that to her employer, correct? That was the requested accommodation.
That's at the very beginning.
I know, I was trying to start from the beginning,
Right,
and
well-
then we can move on, but we apparently can't do that.
Well, I'm not talking about the leave management office where the communications occurred.
Right.
And that
I
can be
am,
very
though.
confusing.
I am though.
Okay, the leave management office said, you have this time, and then pursuant to company policy, you work it out with your supervisor,
Okay.
right? And so she goes to her supervisor and says, I need my schedule reduced because I've got this leave, and the supervisor doesn't do it. Now, there's something called power distance.
What about this letter from the HR service center to her right after she requested that leave that says that it qualifies for leave and it's been approved starting January 15th, 2015, leave end date February 20th, 2015. What about that? And then gives what she must do as part of this dialogue, which is that employee on an intermittent leave of absence must attempt to schedule.
Specificity. The horrible hypothetical from First Data is that if you took all the time that she theoretically wanted for her reduced schedule, she would never be at work.
So after
But you know what?
the leave end date, which the leave end date for the first request was on February 20th, 2015, when did she next make an accommodation request? Because
She said she made it continually. She said she would go to Dawn Row continually. She doesn't have the exact dates.
Was there a time council that she asked for time off
Yes.
specifically and was denied it?
Yes. She said, I don't want to be on the schedule. I want my schedule reduced. And that, to me, that's asking for it. Go ahead.
Okay, that may be, I appreciate that answer. I was asking a little different. Was there a day where she said, I either needed to go to therapy or I need some time off today in the next couple of days? Because was there anything like that? Or I didn't see that. So I take it your answer, and if I'm wrong on that, please let me know. And if I'm right on that, it sounds like your answer is that her request to reduce her hours generally was sufficient.
It was more than one request. It was a continual request. I've been approved for intermittent leave. I need my hours reduced. Dawn Rowe replies, you have to be at work all the time. The hours weren't reduced. And Dawn Rowe didn't initiate a dialogue. Because what you do in Management 101 is you say, how many hours do you need? Why do you need it? It's called the ADA, the interactive requirement. It wasn't
You're
done.
not disputing that the company did approve the leave, at least for the period January 15th to February 20th, 2015, are you?
Our whole theory here is that her immediate supervisor canceled the accommodation clearly provided by the people who were the experts in the company.
So where is and I'm just asking about this first month, January 15th to February 20th, 2015. Where in the record can I find, other than some sort of document, where her supervisor canceled a request for leave that she may have had?
Well, her testimony,
Okay.
she says,
That's right. That's her testimony. I was asking about a document, like a leave request, an email requesting leave, something like that.
well, she
Okay,
works
so
in a
there
call
isn't-
center. She's
so there
not an
isn't
attorney. There's not a procedure that dictates that. There's no affirmative duty for her to do that. In the business world, people will come
I
and
think
talk.
Chief Judge Gregory is trying to speak.
I'm sorry.
Counsel, I think what the question to you, was there anything in the record that would document what you're saying she said? And I'm just saying there is in the record, because the record says that they put her on I guess I would call a PIP type thing, because she had too many absences. So if it was scheduled as she had requested, then they would have known that, but they had to come back. Am I correct? Isn't that the record said? Dawn came back and said, well, oh, no, she really was. So as they didn't know, because there was no schedule time given, correct? Isn't that right?
Well,
these are friendly questions.
I understand that. I'm just looking at my time, and yes, but more important is the idea that her supervisor, I just want to make clear when we say they, her supervisor canceled what the employer granted her by not allowing, is it HR and leave 5 emails or
Instance where
her deposition testimony where the schedule complied with per that they gave me. And
the official, what she asked for was the time off, not just PRN as they were saying pharmacy, but I want schedule to know that she was authorized. I said, oh, she's not here. We don't know why not. Roll back.
It is that putting on a final written warning that led to her termination, where it goes and that she had not done her job. And then basically it's like regrading somebody's homework. Her supervisor went back 3 weeks later. And by the way, what initiated that, just like the first one that they withdrew, what initiated was request for accommodation again. So the supervisor who's never done that before, she testifies, went back and listened to calls, found a call that had passed all scrutiny, and used that for the final written warning. There's animus and hot schedule. And to me, it's a blinding glimpse of the obvious, but I apologize because sometimes I don't communicate as effectively as I should on such a blinding glimpse of the obvious. You're back, the fact we share. So they warned her, you better protect your job. And of course, then what happened when she goes in to get recertified again, she gets nailed again. And
we don't waste your time.
Okay. I'll stop here.
Okay, all right.
It's wonderful to be here with you, and it's a wonderful courtroom. So thanks for having me here today. I'm going to start with the accommodation claim, because it seems like that's where the panel was most interested and focused. And let me just kind of summarize here. I think what really the gist and the crux of this issue is, the sole accommodation request that was ever made here was just the FMLA request. There wasn't some ancillary request for accommodation. She didn't go through the accommodation request process. I asked her at her deposition, your whole claim regarding failure to accommodate is based on this FMLA request. And she says, yes, and my whole accommodation is based on that. And so what
and there was another accommodation request closer to the.
So it wasn't really late. And within days, the employer here approves it. And they say to her, and you noted it in the JA site here, it's 291. We're approving you to have this leave you've asked for.
That's right.
As your doctor said, well, what they did was they told her.
You said they approved it. What did they do?
They told her in the letter, when you need leave, this is how you do it. Engage with your local management.
But they didn't give her what she asked for.
They absolutely.
Schedule is not PRN as needed. It's a schedule. And it is shown in the record because if she had a schedule, someone would have said from part A to part B, this lady is not here because she's on schedule. That's why somebody was saying, well, why is she not here? And HR said, well, you're not here. You're in danger of losing your job. Then the person who should have scheduled back when you had asked for scheduled leave and they didn't even know it, they were ready to put you on disciplinary action. And then afterwards, when you had to come in and say, oh no, she was right, I was wrong. And then, but the parting epilogue was, you need to watch your back. Why? We don't know. You can't answer the question because it's not in the record. But the record is totally, okay, I'll let you go off. Schedule means exactly what it means in the dictionary, schedule.
But that's the issue because the help's a day for 3 to 5 days. So that's the rub. She wants us to interpret it as schedule me for this reduced basis leave. The company interpreted it as, well, we're gonna let you take off as you need to, and that's okay. The law permits that because what else would have they done? 3 to 5 days a week. Should have we scheduled her Monday, Tuesday, Wednesday, but not Thursday, Friday? Or how about Thursday, Friday, and Tuesday? Or how about 2 hours in the morning and 2 hours in the afternoon? The whole notion of the way she was asking it to be certified was.
What about giving her a schedule and then finding out does that work? You can't get to that until you give her a schedule.
Well, as
you're right, you said, well, we gave her a schedule for Friday and Monday, but now we found out, and that's why the law talks about interactive. It's in the middle of the week where she has most of her, she's symptomatic. So let's change it now to Tuesday and Wednesday. But if you never have a schedule, we don't know because it never was, she didn't request PRN. She didn't say, can I be off whenever I don't feel well, my back is hurting? She said, no, schedule. And that's what Judge Thacker read in the record. I've read it too. It's in the record that she asked for that for these days. And she never did. She said, when I'm going to get my schedule? You're not going to get a schedule. I'll let you off when you come and say to me, you need because of either back pain, I guess, or therapy or whatever. That's not a schedule.
Well, as this court has held in the Ray Zuten case, which we cited in our papers and chatted about in our brief, the accommodation and how we give her the accommodation, it may not be exactly as she wanted it, but as long as it's effective. That's what the ADA says. We don't have to give her exactly what she wants or exactly what she requests, as long as the accommodation that the company provides.
How was it effective here?
It's effective because she said it was. The record evidence is replete with that, where she said, yes, on the occasions where I said, I got physical therapy, or I'm not, I mean, she gave a very detailed account of one of the days where she said, I just couldn't do it anymore. I went in, I coded my time as FMLA. I got up, I put my coat on. My supervisor said, are you okay? And she says, no, I'm going home. I said, was there any consequence to you then? She said, no.
If she was pleased with it, why is the record replete with, where am I going to get my schedule? Am I correct? Am I wrong about that? Didn't she continue to say, when am I going to get a schedule? And she never did.
I don't think the record reflects that she continued to say that. She had an initial
several times, right?
And she was told what the accommodation we're providing you is. You tell us when you have.
This is what you're going to get. Is that reasonable? Just because that's what you told?
It absolutely is reasonable because in this case it shows that it was. She came in, she worked, and when she felt like she couldn't work, she took off.
It wasn't reasonable. People have to work, they have to eat, and they have to live. If that was the rule, like, well, you came to work like I told you. I did it because I need to work in spite of my back pain. That can't be the standard for the law. Oh, you must have worked because you came in. Yeah, I came in with a back pain, with what my doctor said I needed. That would turn justice on his head in these cases.
No one forced her to come in. She was told when her leave.
Forced her. Her needs forced her. Eating, living in a home, putting gas in the car, which is very difficult.
Well, whether she was granted leave or not, or came in or not, she was paid by the hour. So if she took off the work, she wasn't going to be paid anyway.
Can I ask you a question about the record of the leave request? Between the time the first intermittent leave request ended, which was February 20th, 2015, and the beginning of the second, which I think was August 15th, 2015, did she request any accommodations between February 20th and August 15th,
she did not.
2015? All right, then What are we to make of what happened when she was ultimately terminated that was so close in time to her second accommodation request?
So, but putting it in the timeline, so the second accommodation request in August came after the July and August incident where she was placed on the improvement action plan. Then she requests to be recertified, and it's a very abbreviated request to be recertified. She's recertified for 1 or 2 days a month as she needs. It wasn't to be reduced schedule. It wasn't take me off the schedule 2 days. It was, you may have off up to 1 to 2 days as you need it. And so what do we make of the next incident? Did it follow close in time? Yes. I mean, she requested recertification for her leave in August, and then she has this other phone call in September. But was this cooked up? Was this, as argued in their papers, that this was a dug up thing? It absolutely wasn't. It was initiated by her own actions on the call that were reported by the caller.
But we don't know what the call, do we have any, where's the recording of the call?
The recording of the call was not kept in the ordinary course and scope.
Oh, so okay, that wasn't kept. It was so important to fire her for it, but not to keep.
Well, again, they make much.
How many years did she work for you?
Approximately 10, 11 years. 10,
11 years, and she she had a problem with a one call and you fired her?
Problem with 2 calls within a 30-day period.
That really ratcheted it up. 2 calls in 11 years of working for you, that occasioned her to be fired?
Yes. They have very, very stringent requirements on how they want their callers. We've all made calls into call centers before, and we get people that we want to give us good, effective, courteous, responsive service, and they have policies. They're in the record. They say, this is how we want our folks.
Let's look at the call that you fired her for. The one call is only 2. She didn't yell at anybody, right?
No, she didn't engage at all.
She didn't use any profanity, correct? Matter of fact, what was the call that the call disengaged and you could hear somebody in the background saying hello?
Yes.
And then she said, but on her end, it seemed like the call was disengaged. She couldn't hear anything, and wouldn't that be consistent? If somebody's saying hello, why would she keep the line open just to be silent? Wouldn't it be consistent that she can't hear the person saying what they were saying? Because it was open for 26 seconds later, right?
Yes.
So that's not a hang up, is it? She didn't disengage, because otherwise, if she had disengaged, you wouldn't have heard the background talking, correct? Am I right? Am I wrong about your telephonic system?
Yeah.
If she hung up, you would not hear anyone talking on the other side, correct?
She did not.
Is that right? No, is that right?
I don't.
I'm asking you a very simple question. If she hangs up her phone, would you continue in your system to hear the other person talk?
Well, no, technology-wise, I guess no, but that's not how their system works.
I didn't ask you that. I asked you a simple question.
You're
saying that she disengaged because somebody was in the background still saying hello. That means she didn't hang up, because if she had hung up, you would have had 26 seconds, right?
No, she put him into the queue. It was 26 seconds.
In the queue.
She put him into the survey queue. That's how he came to be after the call. He did a survey and said, nobody ever greeted me. Nobody ever spoke to me for 26 seconds.
This was his. Oh, that was his survey.
This is the caller survey. The caller called. So 26. He's saying something, and she never greets him. There's no record evidence on that recording that both plaintiff concedes and Ms. Rowe, the supervisor, said, I played this recording and there's no greeting from the plaintiff. She doesn't. By policy, they're supposed to say hello at least 3 times. Hello, hello, are you there? Before disengaging the call.
Well, how long was she on the phone?
Apparently 26 seconds with it never having said anything, and she never says anything on that call, disengages the call, puts him into the survey queue. He gives a survey then that says, nobody ever addressed me, nobody spoke to me, and so I got bad service.
But here's the point. I'm not trying to argue with him, just logic. Wouldn't that be consistent with she couldn't hear him? Because if he's saying hello, there would be 26 seconds of no one responding to him, because apparently she couldn't hear him. Then likely he would not have heard her speak to him.
She could hear him.
How do you know that?
She said that in the deposition. She said, I could hear this person speaking, and I could hear something, what seemed like there was talking in the background. And so the rub here is that
she said, I didn't say a word.
What?
Did she say?
She didn't say that, but she admitted that
What did she say?
She admitted that when the call was played for her, When Ms. Rowe played the call for her, she said, yes, I concede and confirm that when this was played, you cannot hear my voice anywhere on this call. I never greeted, I never spoke. There were no words. Her voice never appeared on that call.
Did she say that I never spoke?
Yeah, she didn't say she never spoke. She said the recording confirmed that she didn't. And that's what we're talking about here. The supervisor can only look at it after the fact and say, hey, I've got this call.
On this case, you fired her 11 years of service.
Yes, they did.
Right, less than a month after she asked for accommodation.
Well, or approximately 7 or 8 months after she asked for her first accommodation.
And she had a perfect evaluation a few months prior to her termination, correct?
Oh,
Well, her mid-year evaluation in 2015 was a 3, and 3 is the maximum.
yeah, but I mean, that's putting aside the fact that she was on a 90-day improvement action plan that said, don't engage in any more call avoidance, and then she did.
How could she have? Seems like it's all the same time period. She's suddenly put on she's put on an improvement action plan about the same time when she's given a perfect performance evaluation of 3, and then she makes another request for accommodation, and this one call happens and she's terminated. I can't square in my mind, and maybe this is reason that there's a genuine issue of fact that should go to the jury. I can't square in my mind a perfect evaluation, and then a few months later, for the one call, she's terminated.
Well,
Can you help me with that?
I don't know that I would use the word perfect, and can't remember exactly what the performance evaluation says. If you point me to it in the joint appendix, I'll take a look at. But I can't get past in my head that she's on a 90-day. I mean, she couldn't have been having excellent performance in the summer of.
I can't. Rose said that at mid-year, Ms. Calgill was ranked a 3. So mid-year to me is a June at the latest. And at 3 in her evaluation, 3 out of 3.
But then
that makes it a perfect evaluation.
So let's say that she had that evaluation in mid-year. I don't recall exactly when it was, but then in July 10, 2015, she engages in the call that results in her being placed on the improvement action plan. And then she receives the improvement action plan in August. That's when she's put on the plan. So yes, the timing is what the timing is, but at the end of the day, the district court determined that there was no evidence to show that the employer's reason for making the termination decision here was pretextual or false, or that there was any other evidence suggesting that the true reason was her disability, that the disability allegedly was the determinative factor here. And points to a lot of things that he says are genuine issues of fact, but there are no genuine issues of fact on that. They've never put anything before the district court or here on appeal to suggest that reason was not the true reason. Judge Gregory may disagree with it and think it's harsh, and you can have that opinion, but there's the decisions from the circuit are replete with the quote that you're not to sit as a super personnel department judging the fairness or wisdom of decisions that employers make.
You're right.
You're just to determine whether or not there was illegal discrimination here, and there was not.
The judges of humanity being maintained in a workplace. You're right. We're not. But we do look at things that are clearly before us. Person who worked there 11 years, and you represent your company, said 2 times the calls. And then at the mid-year, she had perfect records. Heretofore, no problems. You said it was 11 years. And then she asked for re-certification of her disability, her problems. And then less than a month later, she's fired for this call that we just went through. And just listening to that, I mean, it's just, and we can't look at it. This is very recent. Those things we look at because we don't know. We don't know what's in someone's head. But doesn't it raise some serious questions?
Not for me, because I think the recency is a red herring. The recency would be as if she had an FMLA retaliation claim, which she did file and which was dismissed because it was time barred. So if that was the claim we were looking at, perhaps, but the real timing is, I mean, is it so close in time to when she requested the accommodation or the FMLA request, or is it when we became knowledgeable that she had a potential disability? the employer here knew she had a disability going back to January, or at least an alleged disability. And so we're waiting in the weeds to get rid of her and temporarily until September. There's just no evidence of that because it's blocked out and blocked out by, we didn't initiate this. It was initiated by the caller who said, I got bad service.
In this record, why didn't you know that she was supposed to be off when you put her on the plan? The one you had to take back. Why didn't you know? Why didn't they know?
It's not developed in the record.
It's not, but we have to look at that. You're saying that some suggestion of maybe animals.
The record was, I mean, what the record says was, I mean, actually what the record says, it was a mistake. Somebody accidentally counted those absences against her when it should have been FMLA qualifying. So we have put against you. You know, supervisors aren't perfect. They code something in and she brings it to our attention and goes, hey, I've been approved for FMLA leave. You can't count that against me. And they say, hey, you know what? Ms. Colgo, you're right. We're going to rescind that. Sorry about that. That's exactly what happened. That's the record evidence on it. Plain and simple. I have 1 minute left of my time, so I do want to address the arguments he made with respect to the retaliation claim having been exhausted. It absolutely clear. We're not just saying she didn't check the box, and she absolutely.
How long are recordings maintained in the regular course of business of FLE?
I don't know. That's not in the record.
Oh, would you said it, I thought you said it wasn't that this recording wasn't maintained because it wasn't part of the regular course of business.
Yeah, it's a certain amount of time. She requested it in discovery. We went back to the employer and said, do you have? And they said, no, we haven't maintained them. We don't have those calls anymore. We only maintain them for a certain period of time.
Even after they terminate somebody based on the call?
Yes.
So there's no anticipation of litigation at that point?
Well, there was anticipation of litigation, I guess, because, and he makes much of this in his papers, and it's really kind of spurious, but he says they were on notice from the EEOC that they should have held on to this document, but the EEOC charge did not hit the company until October of 2017. They had some sort of internal snafu where they didn't process her charge all the way from the late 15 up to 2017, but it's absolutely clear in the record, we did not get this charge until October of 2017.
But you did know.
And she was terminated 2 years earlier.
But you did know that you fired an 11-year employee who had perfect record scores for one incident. And you knew that would be the sine qua non of your case against her. You knew that then. You didn't have to wait for that. You knew that. I mean, anybody in HR would have to know that. My goodness, this wasn't a progressive thing. Because, it's replete, but she was, the last 5 years, she's been doing the same thing. When you cast all of your bread on the waters of one incident and you fire an 11-year employee who's been otherwise perfect, that is not an issue of spoliation question. Because what else would you keep by this? Look, if you're going to fire this person for that, you better make sure we can document that call and that 26 seconds in that call. But you said, just throw it away, right? You don't know where it is, correct?
Well, I'm sure they held on to it for whatever period of time they held on to it, but we didn't have notice of this. I mean, we can't hold on to every single call forever.
The notice is you fired a person with what I just said, and a person who had requested leave. If that doesn't ring bells and whistles for anybody in HR, I mean, I don't know how HR they'll be in this environment.
Well, first, Judge Gregory, I disagree with the premise of your question that this was one incident. It started in July where she was admittedly rude to a caller and said, well, if I'm not going to argue with you, and she hung up on the person. That's what got her on the IAP in the first place.
Okay, that's one.
And the second one was she was told, hey, in August, you have any more call avoidance, you're going to be terminated.
But she wasn't put on the IAP in July when that call occurred. She was put on that a month later in August.
Correct.
Why was there a delay of a month?
The supervisors periodically go back and review calls. That's what they do in the normal course of their.
Coincide the same month that she asked for recertification. Right.
Well, I'm pretty sure she asked for recertification after the IAP was delivered.
It was in August.
Yeah, I think it came after the second one in August.
August 20th.
August 20th. We put her on the IAP on August 4th. My time is up if you don't have any further questions.
Oh, thank you so much.
Thank you.
Mr. McDermott. Mr. Jellick, you have.
Yes, the record reflects that in the same meeting when she was put on the final written warning, she was advised that her recertification request had been approved. Often when we look at conversations in disciplinary matters, why would you bring up a topic about approving leave at the same time you're telling somebody I'm disciplining you? Talk about mixed strokes or a signal. I think that's a yes, Judge Quattlebaum. If you say to somebody, look, I'm terminating you because of your job performance, but by the way, you've been hanging out with all the Spanish guys in the back. What's that all about? Then there's a suggestion that there's a little bit more going on. And that happens all the time. That happens all the time. My point on the tape that we should be very aware of here is it was requested by unemployment. Within the same time frame that Roe was able to go back and find evidence to put my client on final written warning, at the same time that my client had passed quality control review on this call, that she then went and dug back up. She could find that call, but they couldn't find the tape that led to termination. That's very suspect. Counsel didn't know how long they kept it, but I can tell you the record's pretty clear. It's the same time frame. They had that call within that same time frame for unemployment, and they refused to produce it. I think there's an inference there. But even better than that, Roe's affidavit at paragraph 43.
Unemployment. What was the date of the unemployment where?
I have it, Your Honor, but
yeah. If it's in your briefs or something,
okay. I have it actually written out here. It's just important to hit this here because I think what's really important is we have two different stories from Roe about what was on the tape. So now you have a tape that disappeared. One of her stories in her affidavit, at paragraph 43, says on the recording of the call, a man could be heard talking in the background for approximately 26 seconds, and a man said hello just before Ms. Kogel disconnected the call. That's story one. Story two, she reported at the time she sought to terminate Ms. Kogel. So when the call begins talking, I hear a male talking in your background, a different male voice saying hello at 13 seconds into the call. These are two separate stories. I question the reliability of anything that Ms. Rose says if she can't get her story straight about what she heard on this call that was subsequently destroyed. And the court, therefore, when my client said, I made the opening, and they represented to the court that she admitted she hadn't made the opening. She admitted, because she's a very honest person. She said, Dawn played the tape. I don't believe she played the whole tape for me, but what I heard, I didn't hear the opening. She never admitted she didn't make it. That's an artificer misleading the fact finder. They also allege that she raised her claim in the 11th hour when the record is replete with her saying this from day one. The court below was fooled, and the court missed that there were two separate stories on what the tape said. The court was fooled about her supposedly admitting. And by the way, counsel mentioned earlier that they just made a mistake the first time they issued her a final written warning. It was just a mistake, and we say, no big problem. But watch your back, Paisan, right? What does that mean, watch your back, when you have to watch your back? They didn't say Paisan, but they told her to watch your back. Well, that's not a mistake. That's not where I come from.
That was in February, right?
Yes, that's when she first saw me.
Based on that, she had never had an infraction before that time.
No,
11 years. What's to watch your back? That's what I couldn't understand.
Well, I think it's clear. They wanted to come to work every day because there's pressure on supervisors, notwithstanding the progressive nature of other elements of the company. Congrats to the leadership of the company, the HR department, the people who are trained, who are experts, who did the right thing. And I think that's what Judge Thacker was pursuing earlier, was the idea that at that level, it was appropriate, the granting of the intermittent leave, and then it was canceled out by the person who then had to manage her every day. That person in that office, which probably may not even be in the same location, who knows? They're not aware of what's going on.
The first request for intermittent leave, the letter had a terminus point, which was February 20th, 2015. Between that time and then the August 20th, 2015 request for accommodation, did she make any other requests? Or is this, you're going to tell me about the deposition again?
The same answer I provided before. And again, you have to remember that when she's told to watch her back, right, and she's trying to make a living, she's got a family, and her boss.
The watch your back comment was in February.
Right when this first started. And she goes to the boss and says, I'd like my reduced schedule. and the boss doesn't give it to her. Now, you can, I guess, go hire a lawyer and sue the company. I guess you can do all kinds of things, but the average person does what the boss tells them to do. The boss won't give her the schedule. So she goes to work in pain, and literally she had to tap out. She was in such pain. I actually think that's an adverse employment action. The case of first impression, does it materially alter the terms and conditions of a human being's employment when you force them to work under pain at the risk of losing their job?
That in your complaint?
We didn't plead in the initial pleading but I did argue direct evidence. I think that the threat by Wood to watch your back contemporaneous with seeking this leave is direct evidence. I also would note deviation from disciplinary procedure. Nobody ever got put on final warning the first time. You got somebody watching inappropriate video behavior. These are all short timers, and they get noticed. The one person gets 2 warnings. They get their desk moved, 2 team leaders to help them. She did something where she didn't get any of the other consideration anybody else got. Now, why? All right. Like, what makes this night different than any other night? Well, I think the answer is pretty clear, is that she sought leave, disability leave, and it was disability leave. And I want to point out, too, if you see in the record, their actual disability leave form contemplates short-term disability. So when you're filling out that FMLA form, it says, by the way, if you then have short-term disability, so if someone were to say, try to narrow the law in this remedial statute and try to use the FMLA to disqualify the ADA, right? I would just point out that the employer's own form contemplates disability in taking family medical leave. So deviation from prior policy, 2 acts of timing. The first time she sought certification, then recertification. Comparator evidence, or at least persuasive, if not technically legally comparator evidence. The credibility resolutions by the court below, on, as the court's really noted, this is really an issue for the jury. Our founding fathers recognized that. We can't have persons shading a story to one side or another when the fact is the jury needs to decide. People that actually work for a living and have bosses have to go to the boss and ask for things, have to pay for their kids, are worried about their job. Thank you.
Thank you, counsel. And thank you both for your arguments in this case. We'd love to come down and greet you as we would in our tradition, but we cannot. But no, nonetheless, we're happy that you're here and appreciate your arguments and wish you well and be safe. Thank you, counsel. Mr. Williams?
Thank you, Your Honors, and may it please the court. For more than 50 years, younger abstention has served as a critical safeguard against inappropriate federal interference in certain important state proceedings. The doctrine was tailor-made for circumstances like this case, which implicate ongoing state administrative proceedings about the important state matter of insurance regulation. The district court here recognized that each of the basic Middlesex elements normally calling for younger abstention were present here. And on appeal, even Air Evac seems to recognize much the same, putting up only a half-hearted attack on those factors. But the district court nevertheless lost its way, finding that exceptional circumstances compelled it to nevertheless interject itself into the state proceedings anyway. The district court was wrong to so hold, and this court should reverse. In trying to establish exceptional circumstances on appeal, Air Evac crafts a story of a conspiracy among state regulators, legislators.
Counsel, can I interrupt you before addressing whether there is or is for evaluating the claims made by Air Evac? How do we know whether there's extraordinary circumstances? That was not readily apparent to me from the case law, and maybe there's a position there, but is there a standard or a way we look at that other than just by judging the facts of each particular case?
Well, I think one thing we do know from the cases, Your Honor, is that it's expressly refused to sort of lay out the full field of exceptional circumstances, understanding that the word exceptional itself implies sort of an inability to predict every possible circumstance. But what it did say is elements of bad faith, for instance, or a complete inability of the state judiciary to engage with the claims might themselves establish exceptional circumstances. But this court's decision back in 1981 in the Simopoulos decision, for instance, really stressed that these exceptional circumstances are to be read very, very narrowly. For instance, Air Evac tries to invoke an exceptional circumstances exception based on flagrant and patent unconstitutionality of the state's actions. That case explained that the exception has to be read so narrowly that some have accused the exception basically of being meaningless. That for a made to apply to it has to fail under the applicable federal law. So while I can't give you sort of a rigid three-part test that I might like in an ordinary case, what's obvious from all of these cases is that courts are extremely reluctant to apply the particular exceptional circumstances exception to younger abstention. So
if a court were, counsel, if a court were to determine that the state's actions were designed for protection, competition protection of a state residence versus legitimate out-of-state competition, would that say? And I understand you wouldn't acknowledge that that's what's happened, but hypothetically, if a record established that sort of protectionist efforts, would that be extraordinary circumstances?
Sure. So if we assume an illegitimate protectionist motivation, I don't think that the cases actually say that the motive itself would necessarily be decisive. What we would also have to see as a baseless prosecution that lacks any basis in the law. So what the cases are looking for is a facts or law that affirmatively fail to justify the action that's being undertaken by the state regulator or within the state courts. So it really is something, I think of it almost akin to a Rule 11 standard, where you're looking for a completely baseless state action. And it's not just about sort of these subjective motivations or inclinations of the parties involved. I would say that would be somewhat of a risky test because Younger doesn't just look to the prosecutor, for instance, or in this case, the insurance commissioner. Younger's looking at the entire state structure as a whole. So it would be impossible, I would say, for a federal court to look at state courts and state regulators and the state legislature and assume that all of these individuals in separate parts of state government are effectively colluding to achieve this illegitimate objective. Frankly, that seems so wholly implausible that that's a standard that it's hard to imagine when that could ever be met. So Younger instead more appropriately looks to sort of the objective bases and whether there is any legitimate objective basis for what the state is purporting to do here. And I think what you see on this record, Your Honor, is that there absolutely is. This is not a case in which regulators, legislators, and courts are working together to run Air Evac out of business. It's a case in which an insurance commissioner was reasonably working to respond to legitimate consumer complaints, where you had a legislature who sought to respond to a perceived legislative need, and you had state courts that stood poised to apply both state and federal law to whatever claims or defenses that Air Evac would have wanted to raise. Quite simply, there is nothing nefarious.
What about the fact that in Dodge Rule 2, the district court held that the membership program is not insurance? In light of that, what's the good faith basis for the continuance of the enforcement proceedings?
Well, a few things, Your Honor. One is that Dodge Rule 2's determination was at the preliminary injunction stage. So that Dodge Rule proceeding is still going on. I believe the parties are actually engaged in discovery in that case. So that determination could still be reversed. This court could itself reverse that determination on appeal. So in that way, it's still a live proceeding. The other thing is that Dodge Rule 2 and the injunction that was issued there were specifically targeted towards the new legislation that had been passed by the West Virginia legislature and specific provisions of the West Virginia Insurance Code. It remains to be seen whether there are still other provisions of that particular article that could nevertheless still be enforced against Air Evac, despite the holdings that were found and despite the injunction that was issued in the context of Dodge Rule 2. What's also clear is that the proceeding that was initiated before Dodge Rule 2 it's still there. It has not been ended. It hasn't been canceled. It's obviously not moving forward because of this case, but it's still a live docket in that sense. And in that sense, it's an ongoing proceeding. And while we're just on the subject of Dodge Rule 2, I'll say this. They would like you to use that case to basically determine that there is no ongoing state proceeding that would meet the first Middlesex factor. But every circuit court that we have been able to find looks either to the time that the complaint is filed or the time that the district court is making its younger determination to determine whether or not there's actually an ongoing state proceeding. And of course, Dodge Rule 2 was issued after both of those points in time in this case. So under any appropriate test, whichever one you would choose, it would not be appropriate to use Dodge Rule 2 as a basis to say that there's no longer an ongoing state administrative proceeding. So that actually does take us neatly into the Middlesex factors, which is whether there is an ongoing state proceeding, whether there is an important state interest implicated, and then whether there is an adequate forum for Air Evac to vindicate its federal and state interests. One, of course, is the one that I just addressed. And Air Evac has essentially given up on its other arguments that it made below, that it was too premature or for some reason that the proceeding wasn't right. And is basing its argument on this sort of flawed analysis premised on Dodge Rule 2 that, as we just explained, is not supported. So the second argument that they make is there is no legitimate state interest implicated here, but unfortunately, as they seem to sort of do throughout the brief, they somewhat put the cart before the horse here. They're effectively arguing that because in their view, they are not an insurance product, we cannot invoke our interest in regulating insurance in purporting to take action against Air Evac. But I hate the phrase beg the question or calls the question because it's so cliche, but if ever there were a time for it, it would be this one. That's the whole point of the proceeding, of course, is to determine whether in fact this is an insurance product that is properly subject to regulation by the state of West Virginia. So we, of course, have a generalized interest in the regulation of insurance within the state of West Virginia. And what NOPSI says is that in evaluating the legitimacy and importance of the state interest, you look to the general class of cases that's implicated by this action and not the specific result or the specific individualized action that we're dealing with today. And the general class of cases, of course, is just the regulation of insurance within the state. And on that score, I don't think there can be any debate about the importance of the state interest, not just because of McCarran-Ferguson, but because of statements like those from this court. Back some 30 some years ago, this court was talking about how the regulation of the insurance industry in West Virginia is, quote, a complex state statutory scheme involving policy problems of substantial public importance and interest. That's the Charleston Area Med Center case 6F 3rd 243. So there really can be no debate about the vitality and importance of the state's interest in regulating the insurance market and protecting West Virginia consumers from misleading insurance plans, insolvent insurance plans that really offer no value or risk shifting. And in that sense, that's exactly the sort of interest that the commissioner was seeking to vindicate here. And the third Middlesex factor that we also established is just as important, which is the ability of state forum to offer a place for Air Evac to raise these issues. And Air Evac has really at no point legitimately suggested that it cannot raise these defenses in state forum. They have sometimes suggested that because Commissioner Dodrell, back when he was commissioner, they've at least implied that he would not provide them a fair arbiter when he was going to sit over the administrative hearing. Well, Commissioner Dodrell, of course, is no longer commissioner in West Virginia. But even if we assumed he were still there, and even if we were sort of looking at the facts as they were at that point, we're overlooking the fact that the state courts still have de novo review over legal issues of the sort that Air Evac is raising here. So you have both a state circuit court that would look at these preemption issues and make its own determination, and the West Virginia Supreme Court of Appeals, which would likewise be making its own de novo determination. And of course, these courts, while not bound by the Fourth Circuit, will act informed by and educated by the same sorts of cases that this court would in applying the law, or in this case. So of course, those courts would consider decisions like Cheatham or decisions in other circuits or whatever authority that Air Evac chose to summon. We would in turn cite our own authority. The Hundley decision in the Southern District of West Virginia rejected a motion to dismiss.
Does the recent federal legislation, the No Surprise Act,
right,
bear on this litigation at all? And that act bans the surprise billing by air ambulance providers.
What I think the No Surprises Act does, Your Honor, is it sort of rebuts the suggestion that Air Evac is trying to raise, that there is no place for states in the regulation of air ambulance services. And coincidentally, that was also rejected by Cheatham, but we can leave that alone for the moment. The No Surprises Act specifically gives a role for states to implement some of the provisions of the No Surprises Act. And in West Virginia, the offices of the insurance commissioner are the party that's specifically charged with implementing the provisions of the No Surprise Act. So again, it's a further reflection of how Congress itself is contemplating a role for states in this area. And the state legislature has in turn contemplated that the insurance commissioner will be the one to vindicate the state's interests when it comes to these sorts of considerations. So I think if anything, Your Honor, the No Surprises Act only supports our position that unlike Air Evac's position, this is not a hands-off, totally forbidden, no state approach kind of world that we're living in, that states do still have a role to play in this area. So especially given considerations like that, and especially given the fact that the Middlesex factors are all met, we go into the exceptional factors approach with all of these sorts of leanings and biases for abstention. And basically what we hear is a tale in which a commissioner wanted to advance consumer interests. We hear a suggestion that this commissioner is working with Health Net, for instance. Well, Health Net was the complainant. So yes, the commissioner was communicating to a limited extent with Health Net as the complainant about efforts that it might be undertaking that are relevant to the air ambulance industry and some of these subscription plans. And we hear a suggestion, for instance, that the commissioner was engaged with the legislature on some of these issues. Well, first, I don't see anything nefarious in a state regulator working with legislatures to implement legislative solutions to problems that arise in the course of regulation. But it's also misleading to suggest that the commissioner was behind this specific bill. He was not. In fact, if you look at the record, actually, if you look at the specific addendum that was supplied by Air Evac, they cite, I believe, pages 44 through 46. But if you look at page 46, there's actually a question posed to Commissioner Dodrell: were you involved directly or indirectly in the drafting of this bill? And he answers no. So although Commissioner Dodrell was initially involved in a draft of a different piece of model legislation that was put out by a different organization, the bill that ultimately was passed by the West Virginia legislature was based on the NCOIL model bill, so a conference of legislatures bill, as opposed to the National Insurance Commissioner's model legislation, which was not what the West Virginia legislature ultimately passed. So even this idea that the West Virginia Commissioner of Insurance was
So he was involved initially in some way, but just not with the actual bill that was ultimately passed?
Correct. And Your Honor, it's entirely appropriate, as I said, for our commissioner to say, I see a problem. Maybe it would be a good idea for the legislature to address this directly rather than me trying to do it indirectly through administrative regulation. So there is nothing nefarious in a suggestion that a state agency is talking with legislators or working with legislators to put forth legislation. And ultimately, in this case, the legislature independently came up with its own solution that it thought was the best answer. And although in Dodgel 2, it remains to be seen whether that did in fact prove to be the best answer, attempting to address a legitimate consumer concern is not a sign of bad faith or a sign of ill will sufficient to defeat all deference to state administrative tribunals. So I would just suggest that, honestly, Your Honor, what much of what we see here is basically the ordinary functioning of state government. And while there seems to be an attempt to make this an inappropriate action, the record belies most of those characterizations. So for all these reasons, we would simply ask that you reverse the finding of the district court, reverse the injunction, and allow this proceeding to move forward in state proceedings. With that, I would reserve the rest of my time for rebuttal.
Thank you, Mr. Williams.
Thank you.
Ms. Taylor.
Thank you, Your Honors. May it please the court. Charlotte Taylor on behalf of Beck. The district court did not abuse its discretion in declining to abstain. Even if the three Middlesex factors were present in this case, and we dispute that they are, it presents extraordinary circumstances under which younger abstention would be a misbegotten exercise in formalism. Among these are first, the fact that ever since this court held in Cheatham that state laws regulating AirVac's membership program are preempted by the Airline Deregulation Act, the commissioner and other state actors have been deliberately searching for ways to circumvent that holding and regulate AirVac. Second, AirVac will not get a fair hearing in the administrative enforcement proceeding, which was begun in collusion with AirVac's in-state competitor and which the commissioner expressly stated at the outset was aimed at shutting down AirVac's membership business, not bringing it into compliance with the insurance code, not working on specific consumer concerns to rectify those, but shutting it down. Third, there's unanimity among the federal courts that the state's asserted interest does not in fact apply here. This is not the regulation of the, quote, the business of insurance, which is the only area that Congress reserved for the states with the McCarran-Ferguson Act.
Why can't West Virginia look at that and decide? I mean, that's the point of the proceeding, or at least one of the points. I mean, why wouldn't West Virginia in its investigative process be able to say, okay, we're looking into this as, insurance or it's not, and if they make a determination that it is, you appeal it, the court look at that and say it's not? I mean, why? I mean, that you may be right. I'm not really quarreling whether it is or is not insurance, but why can't West Virginia and its court system determine that?
Well, as an initial matter, we know that the administrative enforcement proceeding was prejudged. Again, it was stated at the outset that the purpose of it was to shut this business down. The very pendency of the investigation.
And I'm asked you a question, didn't I? That's not, but if you could include in your answer, and I'll try to be quiet, whether that is amounting to bad faith. I mean, because if it's bad faith, that's one thing. The district court didn't make that finding. And is that argument a bad faith argument? So I'll try to be quiet now and let you maybe handle both of those.
Again, the district court did stop short of finding expressly bad faith. She indicated that she was very troubled by the facts and that there could be further, if this court disagrees that with the analysis that the district court made, remand for further fact finding on bad faith would be appropriate. But again, the point of the extraordinary circumstances inquiry, which the Supreme Court stated in Younger, that it was going to be impossible to delineate all the areas where this might arise, is that you might have cases that don't perfectly fit bad faith or patently unconstitutional, but where you have the state insurance commissioner stating at the outset that the the entire proceeding was designed to shut us down, again, not to bring us into compliance with state law, then informs our in-state competitor that the investigation is ongoing before we know that it's ongoing. That in-state competitor takes that information and shares it with the Roane County Chamber of Commerce, again, before we're aware of the investigation, actively using that knowledge to try to undermine our business relationships. There's enough indicia that he also appointed himself judge and jury instead of having an independent ALJ be the hearing officer. Commissioner Dodge will determine that he was going to sit as the hearing officer. In all of those circumstances, I think there's sufficient evidence that there was a deliberate effort to circumvent Cheatham and a deliberate attempt to shut us down. If that was all we had, stopping short of bad faith, then maybe we could, we would be having a different conversation here. But at the same time, what we have is a unanimous federal consensus that this is not, in fact, regulation of the business of insurance. So first we had, of course, Judge Berger below issuing her preliminary injunction and holding that we are likely to succeed on the merits. Then the Eighth Circuit in Guardian Flight, in an opinion that the state nowhere cites anywhere in its briefs or addresses, not only held that the same membership program is not the business of insurance, but actually cited and relied upon Judge Berger's decision. And then, of course, Chief Judge Johnston recently issued his preliminary injunction, again, holding that we are likely to succeed on the merits of showing that this is not the business of insurance. The federal courts don't have to turn a blind eye to all of that authority when it appears in conjunction with these actions of the commissioner that indicated that this proceeding was intended to drive us out of business. I want to get back to Your Honor's question also about why we can't present this in the state courts with a couple of points. One is that my friend suggested that even if this proceeding was infected with bias, that is okay because that could be cured by de novo review in the state courts. But that's directly contrary to the Supreme Court's holding in Gibson v. Berryhill, where the Supreme Court expressly held that even the possibility of eventual de novo review doesn't cure a problem of bad faith or bias under Younger. And the other point that I would make as a practical matter is that as we've seen, just the pendency of the enforcement proceeding itself is already inflicting harm on our business, both because we know that HealthNet was going out into the market and using the pendency of the investigation against us to try to undermine our business relationships, but also as we have indicated that we have all these ongoing contracts, this is in the record, with municipalities, with fire departments, with businesses, as well as with individual consumers. And the uncertainty as to whether the program is going to be allowed to continue is, as we speak, undermining our ability to, make the case that continuing those business relationships is the right decision.
Yeah, I can appreciate that. I think that I'm just trying to put this. It seems like that would be a risk in any state regulatory situation, the ultimate results of which could be severe. Like, I'm not suggesting these aren't. And so, without debating that just seems like that would be something that happens as a reality of state regulatory efforts. And here the allegations are that it's insurance, and insurance would, I think, pretty clearly be something that the state would be entitled to regulate. You obviously contest that vigorously and cite to authority that is to the contrary. And I'm trying to wrestle with the notion of how we as a federal court get to stick our hands into the state system that, at least on the surface, is about insurance. And it's not like it's a car wash that they're saying insurance. It's got some stuff that you disagree with, but might have some indicia of insurance. Just seems to me like what you're asking us to do is an extraordinary thing. And I'm having trouble with I guess grasping how the events here would rise to the level that the courts have talked about that would allow an exception to younger?
Again, I think if there was only one of these factors that we might not have extraordinary circumstances, but I think with all the collection of the factors that we do meet that. For example, you know, in the Forst case, this court held that there were extraordinary circumstances because Congress had made a determination that railroads wouldn't get a fair hearing in state fora when it came to a tax dispute. Now, conceitedly, we don't have a congressional determination that the state courts are unreliable, you know, writ large in this area, but we do have objective evidence that the administrative proceeding was begun in an effort to shut us down in collusion with our in-state competitor, and that it effectively we're not going to get a fair hearing in that proceeding.
The district court said the state courts didn't do a lot on this, but it said while capable, it said it was troubled by the timeline. So that seems pretty different, of finding below that the state courts are capable, you know, with a congressional determination that you can't get a fair hearing.
Well, I think when there's actual evidence of bias in the record and a statement by the adjudicator that the end result of this was going to be to shut down our business, I don't know how you would feel as a litigant entering into that kind of a scenario, but I think that it's a very fair conclusion that the district court, drew that is at a minimum troubling, and we would, submit does suggest bad faith and that the outcome has been prejudged. And then again, you also have a unanimous federal consensus that the asserted state interest is invalid, that this is not the business of insurance. And we know that they were trying to find a way to circumvent this court's holding in Cheatham. This is the one that they came up with, but it's in fact doesn't hold water as a matter of federal law. I wanted to address the suggestion that this enforcement proceeding was undertaken to redress consumer complaints. I believe that my friend acknowledged that actually the complainant was our in-state competitor. Commissioner Dodgewell doesn't get very specific on the allegation that there are consumer complaints, but to our knowledge, and this is something that you can see footnote 8 in Chief Judge Johnston's opinion in the parallel proceeding, that he has yet to see evidence of consumer complaints about the membership program, and we're aware of one. And that's significant because, as Judge Berger noted, it's unclear why the state is so dead set on ending the membership program when it is a way of allowing consumers to prepay for air ambulance services at a discount, and also a way for municipalities such as Logan County to make the decision that they are going to buy memberships, buy this discounted service for their entire set of residents who live there. This is ultimately not a case where the commissioner is stepping in somehow to respond to a real problem on the part of consumers. With respect to the No Surprises Act, this is a complicated question, and I would be happy if the court is interested to submit a supplemental brief on this, but I will say that the No Surprises Act, while it does contemplate a role for state insurance regulators in some areas, specifically was drafted with the recognition that air ambulances are covered by the Airline Deregulation Act, and effectively carves them out of some of those provisions that do allow for concurrent participation by the states. I believe, with respect to the question about whether the extraordinary circumstances inquiry might somehow be, doesn't have clear guiding principles, I do think, again, that the Supreme Court has acknowledged multiple times that they, it's not possible to narrowly delineate the circumstances in which extraordinary, there are going to be extraordinary factors. But I think if you look at the exceptions to younger preemption overall, you can glean principles that can guide how the court should proceed here. So there is an exception for patently unconstitutional state legislation, and there's also an exception for bad faith. What both of those indicate is that federal courts don't have to sit on their hands when there's some indication that the state proceeding is not the ordinary good faith prosecution that Younger specifically says federal courts can't intervene in. When you're only dealing with the type of injury of, the anxiety and expense and trouble of an ordinary good faith prosecution, that's where Younger applies. But when there's some reason to believe that we're outside that category, whether it's, subjective bad faith or patently unconstitutional state law, then you no longer are in that category of Younger cases where deference to the state forum is called for. And again, here we can debate, and I think there would be a need for further fact finding on whether we get all the way to bad faith. And we could also debate whether this is a facially conclusive preemption claim. But when you add all of that together, we do get to the level of those concerns that Younger leaves room for, which is the federal court doesn't have to just turn a blind eye when there's reason to believe that the state proceeding isn't an ordinary good faith proceeding entitled to that kind of deference. One point that I did want to make as well is that the question whether this court can look at subsequent events to the date of filing, my friend has suggested that the court's hands are tied, that it can't look at anything that happened after either the administrative complaint was filed against us or we filed our federal complaint. That's not the case. If you look at the Supreme Court's decision in Middlesex County itself, which is obviously a seminal decision, the Supreme Court looked at subsequent developments, and in fact, Justice Marshall had a concurrence joined by 3 other members of the court, making explicit that the reason why he was persuaded to join the court's opinion was that the court had taken into account subsequent developments in the landscape surrounding the question whether Younger abstention should apply. And if you would like a federal court decision that also holds that the fact that a ongoing state proceeding is no longer pending after the moment that the federal complaint was filed, I can give you a citation. That would be Pathways v. Dunn, 329 F. 3rd, 108. That's a Second Circuit decision from 2003. Overall, again, I think the fundamental point is that federal courts don't have to be bound. While extraordinary circumstances is a high bar, federal courts don't have to pretend not to see factors that suggest that the state proceeding is not going to give the federal litigant a fair chance to present its federal claims. If the court has no further questions, I'll rest on my briefs at that point. Thank you.
Thank you, Mr. Taylor.
Thank you.
Mr. Williams?
Yes, Your Honor. In brief, we heard a number of suggestions, both in the briefs and just now, that these are unusual factual circumstances that justify a departure from the ordinary, narrow circumstances in which exceptional circumstances can be found.
Mr. Williams?
Yes, Your Honor.
Do you think the jurisprudential landscape makes a difference of the circumstance?
I think the jurisprudential landscape can make a difference, but maybe in a much narrower way than was just suggested.
It's pretty broad in terms of what the federal courts have said about this area.
Well, what I would say, Your Honor, is that in cases applying Younger abstention, they have said that when a case in state court is patently and flagrantly unconstitutional, then in that circumstance, it might be appropriate for exceptional circumstances to be found and for Younger abstention not to apply.
What about the same question that's ultimately before the federal court now is the one that has been opined by other federal courts, and they have been sort of unanimous about their holding?
So what I would humbly suggest, Your Honor, is that that's not entirely fair.
Okay.
There were in fact decisions, some of them district court decisions that admittedly have since been revisited, A North Dakota decision, for instance, I would cite the Hunley decision in the Southern District of West Virginia, which again denied a motion to dismiss from air evac, premised on the idea that they were not insurance. So it's not, in fact, the case that every single court that has ever looked at this issue agrees that they're not insurance. But that said, again, that's the entire point of the state proceeding, is to determine exactly that question.
You indicated that the state proceeding was started as a result of consumer complaints, plural. Where can I find these citizen complaints in the record?
So let me be clear, Your Honor. The specific proceeding that started here was a result of a complaint from HealthNet, as I understand it.
From the competitor?
Correct.
Okay, yes, I thought I heard you say earlier something about consumer complaints.
Yes, Your Honor.
Some outcry.
I'm happy you actually anticipated a point that I did want to make, which is that the commissioner receives complaints not just in sort of a written official form, but they hear things on social media. They hear things like from a legislature passing on consumer complaints. You actually heard mention, for instance, of Air Evac talking about their arrangement with Logan County. As I understand it, for instance, the commissioner's offices heard on social media some concern from residents of Logan County about the fees that they were being asked to pay and whether they were actually receiving any services from them.
Was it the commissioner's social media that somebody was writing into like you would if it was a complaint?
So I will be frank, Your Honor, I do not have that level of detail.
Okay. It sounds like there weren't any consumer complaints then outside of the competitor complaining.
So I will absolutely be clear that, yes, Your Honor.
There was chatter on social media.
Right.
By some unknown
It is a matter sort of reality, Your Honor, that state regulators often sort of respond to these chatter or legislative concerns that arise in less direct ways. And I think that the sort of pervasive efforts to regulate these sorts of plans are a reflection of the fact that consumers really are concerned about whether they're receiving value and whether they are in fact being treated fairly by these organizations. So that ultimately is what led the commissioner to act here. It was not some nefarious plan or conspiracy. It really
Counsel, if I could interrupt and ask one more thing, and I know we're over, so I'll be brief, but you made the point in your initial argument that we should look at the state judicial system as a whole.
Yes, Your Honor.
Your colleague says the Berryhill case suggests that's not the case.
Right.
Assume we think there's at least some evidence that would support the district court's decision of extraordinary circumstances relating to the proceedings, the administrative proceedings. Would you please respond to the point that we can't limit our analysis there and we must look to the state judicial system as a whole? Or if that's your position?
Well, I think that's the position of the younger cases in general, Your Honor. The younger cases ask whether state tribunals fairly offer an appropriate forum for these sorts of claims to be made. So if there's de novo review at both the circuit level and the Supreme Court level, that would seem to be a part of the state court forum. I will say that in Gibson v. Berryhill, they said that a different result would not be required simply because some judicial review might be forthcoming. But in this case, there's both not an indication of, or not a finding rather, by the lower court of actual bias on the part of the decision maker. And by the way, that's no longer the decision maker should this go back. That the Commissioner Godrell is not actually going to be the one who hears this should it go back. But in addition, there will be further review both by the circuit court and by the West Virginia Supreme Court of Appeals. So all that, given that Younger looks to the state court system as a whole, seems decidedly relevant as to the fundamental question of whether they will get a fair shake in West Virginia courts. So for those reasons, Your Honor, we would just ask that you reverse the decision of the lower court. Thank you.
Thank you, Mr. Williams, and thank you, Ms. Taylor, for your arguments. And Ms. Taylor, we can't greet you as we would ordinarily could. And Mr. Williams, same here. And but please know that we appreciate your arguments here today, and we wish you well. And be safe. Thank you so much. With that, I'll ask the deputy clerk to adjourn the court until this afternoon.
The honorable court stands adjourned until this afternoon. God save the United States and this honorable court.